something else. I'm gathering I should start by walking through these and trying to adapt them to the online part. But let me see if. So I think I'm supposed to ask everybody if each side is ready for trial. So please go ahead.
Your Honor, if I may request that our opposing counsel and our counsel exchange trial rosters, either via screen share or
Very good. And I, by the way, you started to break up at the last part of that. So I heard a request to exchange screen trial rosters. And of course, that's granted. Why don't I should introduce the scorers. Why don't the scorers introduce themselves?
I'll jump in. My name is Carl Berg. I'm a construction lawyer here in Colorado Springs.
I'm Charles Brown, and I'm a real estate broker here in Colorado Springs.
I'm Tim Calling. I'm a healthcare leader at Penrose St. Francis Hospitals.
You let everybody in the courtroom.
Thank you. Thank you for the scorers. I think anyway, I'll go back to the participants. I think I asked if each side was ready, and I got the request to exchange rosters. Is each side ready for trial?
So I am just waiting to see the defense to, oh, here we go.
I'm going to ask for help with this. Is this the trial roster? The first thing I'm going to, once I get past these procedures, is I remember from past times, the most important thing for me and the scorers is to start putting names to faces and figuring out what role each of you is playing. And it looks like this is the first step there. Is this, I'm trying to figure out, anyone else can jump in, such as the scorers or any of the participants. It looks like this is something that we can all print out. Does anyone know how to print off this screen?
So if the defense would share this document through the chat function, there's an option for file, and then you just insert a file. That's the way that I shared our rosters. I'm sure that the judge and the scoring panelists can also download these documents and print from there.
Yes, I received the prosecution's trial roster through the chat, so that works great.
Good, I think I've got it too. Okay, and are we going to get this is the prosecution trial roster? We're going to get the defense one as well that way?
Yes, Your Honor, I'm just pulling it up.
Thanks.
You all look so serious.
And I know technical difficulties will do that to me.
What is this?
There's this feeling that nothing will work, until it actually works. There's a feeling of complete helplessness that nothing will come up on the screen and I won't know what I'm doing. So if I'm feeling that here, and I've been doing this in real life for these years, I can only imagine what our participants are feeling. So At any rate, you're going to be put in the position here of the masters. I'm going to be asking you for help on all of these things because this is different from what I do on a day-to-day basis. Okay, I see the defense roster. I'm going to try and pull that up. And are the scorers having success as well in bringing up and printing or putting on their screen the trial rosters?
Yes, Judge.
Great. Okay, I'm probably the slowest of you all, so thank you, everybody. Does that mean that the answer is, now that we've got those rosters, does it mean that the prosecution is ready for trial?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
All right, thank you. I'm going to muddle my way through these pretrial procedures, which I understand have not been completely adapted for our Zoom presentation today. Okay, I'm required to confirm that if video recorders are present and being used, that both teams have approved the taping of the round. Is there any agreement about taping? Or I guess if there isn't, I understand there won't be any taping. Is that right?
The prosecution agrees to any taping that may be happening.
Your Honor, this is Jackie Gacy. I'm on Jason's team. There is a live stream YouTube that is happening for parents to be able to watch. So I'm not sure if that qualifies as recording or not. But as far as I know, there's no recording of the actual sessions allowed by anybody on video, on YouTube or anything. To record them, that some other team might get a hold of them. But there is private rooms for parents and coaches to watch via YouTube.
Very good, thanks. I see the next thing on the list is, and I don't know if this applies during this year, but I'm supposed to inform everybody that the Colorado Bar Association may be taking photographs. Is that something that's happening over Zoom, or should I just skip that one?
I would just skip that one.
All right. And is there anyone in the gallery who's connected with teams not competing in this round? If there is, you're asked to leave the courtroom now. Next, I'm reminding the teams that no recesses will be allowed, with the exception of those granted for health emergency. And it says, and especially not between the end of witness examination and the beginning of closing arguments. Jackie, can I ask for your follow-up? I think we heard something slightly different in orientation. One judge asked, is it allowed to give a brief break before closing arguments? So, and I think Jason said yes, so I'm not quite sure what's the right answer right now on that one.
I know historically when we've been in person, they are not allowed to have a break. I don't know why it would be different for this.
Okay. All right.
But if one of the other scorekeepers heard differently, please chime in.
We'll
Mr.
go with
Colling
that
or
unless
Mr.
I
Burr?
hear.
Sorry, I was just asking them to let us know if I misunderstood.
I heard that it was at the judge's discretion.
It's at the judge's discretion. So.
It's okay. All right. I'll allow about a minute before closing argument. Okay. Does that, I'll just go through the rest of this then. Okay. All right. Now I have a question for the scoring panelists. The question for each of the scoring panelists is, do any of you have any reason to be biased in judging either team?
No.
Have I heard from all three? I think I heard just two no's. I can't see Mr. Brown. I assume his answer is no, but at the moment he's disappeared from the screen and he's muted. Mr. Brown, are you still there? Okay. I think
No.
I saw you, but didn't. Okay, thank you. All right. All right, then I'm supposed to remind the teams and coaches that any disputes arising out of the competition must be reported in accordance with the competition rules. And as to the teams, your compliance with time requirements will be considered in scoring individual performances. Now, I need to confirm that no coach or team member other than a timekeeper is seated in the jury box. Well, I guess, all right. I think in the virtual jury boxes, I think we just have our scorekeepers. All right. I'm going to ask each side to introduce the participating team members. I'm going to ask you to go slow, and also any of the scoring panelists can also ask to hold up if you need more time. I'm going to try and let's see. What I'm going to try and do, the way I'm going to do it, this is to help me out, is to try and enter your names on the score sheet. I assume I could do this just by following the trial rosters, but I haven't had the time yet to enter your names. So I'll ask you to each introduce yourself, and unless you can correct me if there's a better way of going about this, but I think I need first the team code for the plaintiff, and then I'm going to ask for the team code for the defense, and then I'm just going to follow the order that's in the score sheet so that I can fill in my score sheet and the other scorers can do the same in that order. So I'm going to be going through and asking for student names, who's going to do the plaintiff opening, who's going to do the defense opening, and so forth. And if anyone else needs more time, you can slow me down. So let me ask, what's the team code for the plaintiff first?
Your Honor, I believe that code would be 2.
Q. Thank you. And the team code for the defense?
1, Your Honor.
1. Thank you. If my computer will, cooperate. Okay, now it is. All right. Would the student, a second. All right. The student giving the prosecution opening, please introduce yourself.
Your Honor, members of the jury and opposing counsel, my name is Ginger Hartman, and I will be delivering the opening statement for the prosecution.
Welcome. Why don't I'm going to go down the left side of the score sheet, so we'll do the prosecution students first. So would the prosecution counsel number, right now you're identified as counsel 1, counsel 2, counsel 3, and then they're going to be witness 1, witness 2. And then it says witness 1 again. I'm not quite sure. It's probably intended to be a 3 after that. Okay. Prosecution counsel 1, please introduce yourself.
Your Honor, members of the jury, opposing counsel, my name is Katie Hunter. I will be directing Detective Markowitz and crossing Avery Becker.
Could you help me out by identifying that on the score sheet? They're identified as plaintiff, or it says plaintiff rather than prosecution, witness 1, 2, and 3. Could you and everyone who follows please just tell me I'll be use the witness numbers rather than the names, and that'll help us all in entering your names on the score sheet?
Your Honor, if we could ask for some clarification, the witnesses, I don't believe that they're assigned a definitive number. Are you? Can I ask if that number would be associated with the order that they go in our case?
Well, that would be my best guess. Sure. Yes. That would make sense. And so I don't know if you have seen the score sheet, but it says plaintiff, it should say prosecution, but plaintiff, counsel 1, counsel 2, and counsel 3, and then it says witness 1, witness 2, and the next one I'm going to assume means 3, even though it says 1 again. So yeah, if we do it by order, can you, as you introduce yourself, tell me which number witness you're going to be responsible for? Does that make sense?
If you would like, Your Honor, our witnesses could introduce ourselves first so that you can get our names for each number. And then after that, you could get our attorneys to tell you who's directing and crossing each witness in order to make it more clear on who's doing who. And so our witnesses could get numbered, if that would work easier.
Perfect, thank you. That works.
Your Honor, members of the jury and opposing counsel, my name is Crystal Caruana and I am Jordan Markowitz. I am witness number 3.
Okay, thank you. Thank you. I guess you're suggesting the other witnesses introduce themselves as well?
Yes, sir.
So go ahead with prosecution witness 1.
Your Honor, members of the jury and opposing counsel, my name is Kaylin Regath and I am Kyle Kuzak. I am witness number 1.
Good afternoon, thank you. Witness number 2, please.
Your Honor, members of the jury, opposing counsel, my name is Aaron Amella, and I am Alex Fuentes, and I am witness number 2.
Thank you. And we were going to double back to the counsel. We have, so next, plaintiff or prosecution counsel number 2.
Your Honor, members of the jury and opposing counsel, I will be giving the opening statement, like I said earlier. I will be directing Alex Cifuentes, who is our second witness, and I will be cross-examining Blake Van Owen.
Thank you. And plaintiff counsel or prosecution counsel number 3, please.
Your Honor, members of the jury, opposing counsel, my name is Katie Hunter. I will be directing Detective Markowitz and crossing Avery Becker. I am counsel number 3.
Then I made a mistake. Thank you. I made a mistake. I think I had you down as counsel 1. So who is plaintiff or prosecution counsel 1 then?
Your Honor, members of the jury and opposing counsel, my name is Nicholas DeSalvo. I will be directing Kyle Kuzak, which is witness number 1, cross-examining Taylor Perkins, and I will also be delivering our closing argument.
Good afternoon. Let's do the same thing for the defense. So the student who is giving the defense opening, please introduce yourself.
Your Honor, opposing counsel and members of the jury, my name is Sydney Pavetti-Henke, and I will be giving the opening statement for the defense.
Good afternoon. And then we'll do it the same order we did with the prosecution. So defense witness number 1.
Your Honor, opposing counsel and members of the jury, my name is Alex Larkin, and I am Taylor Perkins, or defense witness number 1.
Good afternoon. Now defense witness number 2, please.
Your Honor, my name is Haley Schumacher, and I am Blake Van Owen, also witness number 2.
Good afternoon. And now defense witness number 3, please.
Your Honor, opposing counsel and members of the jury, I'm Cassidy Rude, and I'm Avery Becker, defendant number 3.
Good afternoon. I think I neglected to ask for the names for the closings. I'll do the defense first and then the prosecution. So the defense closing.
Your Honor, opposing counsel and members of the jury, my name is Royal Zias McCall, and I will be providing the closing argument for the defense.
Good afternoon. And who will be providing the closing for the prosecution?
Your Honor, members of the jury and opposing counsel, my name is Nicholas DeSalvo, and I will be providing the closing argument for the prosecution.
Good afternoon again. Thank you. Right. I'm checking my sheet to see if there's anything else I need to address before we start.
Your Honor?
All right. Yes.
Can we go
Yes.
through the list again based off of our score sheets so that at least I make sure I've got it correct? I'm not sure.
Your Honor,
Go.
I apologize. Your Honor, before we do that, I'm trying to write these down too, to keep track of them on our side. I didn't get who the counsel is for defendants.
Oh, thank you very much. I'm a little scattered this afternoon. I appreciate it. Let me go there next. All right. So we've done the defense witnesses, and now we need the defense counsel number 1.
Your Honor, opposing counsel, and members of the jury. My name is Natalia Quinones, and I will be conducting the cross-examination of Kyle Kuzak and the direct examination of Taylor Perkins.
Good afternoon. Thank you. And defense counsel number 2, please.
Your Honor, opposing counsel, and members of the jury, my name is Royal Zias McCall, and I will be conducting the cross-examination of Detective Jordan Markowitz and the direct examination of Professor Blake Van Owen.
Thank you. And defense counsel number 3.
Your Honor, opposing counsel, and members of the jury, my name is Sydney Pavetti-Hinkie, and I will be conducting the cross-examination of Alex Fuentes and the direct examination of Avery Becker.
Thank you. Let's see, did I fill in the gaps? Mr. Brown, and other scorers, did that fill in the gaps that I had left before?
No, sir. I'd like to go down the list, starting on the left side, the plaintiff opening, and just double check all the names so that I know that I've got them in the right place.
Why don't I recite what I have? And I'm going to go down the list on the left side, and then anyone can correct me if I got it wrong. Okay, plaintiff opening, I have Ginger Hartman. Plaintiff counsel 1, Nicholas DeSalvo. Plaintiff counsel number 2, Ginger Hartman. I'm reading plaintiff because I'm reading off the score sheet rather than prosecution. Plaintiff counsel number 3, Katie Hunter. Plaintiff witness number 1, Kaylin Regas. Plaintiff witness number 2, Aaron Amila. Plaintiff witness, it says 1, but it means 3, I assume, here on the score sheet, Crystal Caruana. And plaintiff closing, Nicholas DeSalvo. Did I miss anything there? Okay, that looks correct. I'm gathering from Mr. DeSalvo's response. Okay. And so I'll go down the right side of the sheet. Defense opening, Sydney Pavetti-Hickey. Defense counsel number 1, Natalia Quinones. Defense counsel number 2, Royal Zias McCall. Defense counsel number 3, Sydney Pavetti-Hickey. Defense witness number 1, Alex Larkin. Defense witness number 2, Haley Schumacher. And defense witness number 3, Cassidy Rude. And defense closing given by Royal Zias McCall. So defense, did I get those right?
Your Honor.
Yes, Your Honor.
Not.
Your Honor, if I may, it's Hinkie, not Hickey.
Okay, I think it was the way it was written down on one of the documents, H-A-K-E-Y?
H-A-N-K-E-Y.
Okay, thank you. I
Thank
think
you,
I
Your
was
Honor.
following that. Thank you for the correction. No one wants to have their name wrong. I know that. Thank you. And Mr. Brown, do you, or any other scorekeepers, do you have any other questions on that?
No, Judge.
Okay. Very good. Let me go back and see if there's anything else I needed to cover on the list of pretrial matters. 1 second. I think next is to swear in the team members, the gallery, the scoring panelists, and the witnesses. So give me a second. That means I need to find the oaths that you use for this process. And I think that looks like they're right here. All right. So I will ask everybody in the courtroom to please stand for the swearing in. In an effort to maintain a level of professionalism and to uphold the code of ethical conduct during and after these mock trial proceedings, all members of the gallery, scoring panels, and teams shall stand for the swearing in to the oath of the code of ethical conduct. I can't see very well if everybody's standing. It really looks like some of you are sitting, but I can't tell. So those who are sitting, please, everybody, please stand and please raise, team members now. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay,
Yes,
we
Your Honor.
always learn things that are awkward on Zoom as we go forward. So everybody was muted. I don't think I have the technical capability or don't know how to do it to unmute everybody together. So why doesn't all the team members please unmute yourself right now? So, and then I can hear you all say, yes, Your Honor.
Yes, Your Honor.
Take a second,
Yes, Your
make
Honor.
sure you're unmuted.
Yes,
Go
Your
ahead
Honor.
with the response.
Yes, Your Honor.
Yes, Your Honor.
Thank you, everybody. Okay, team members, you can lower your right hands. Witnesses, please unmute yourselves. Team members, mute yourselves again. Witnesses, all unmute yourselves, and then please stand and raise your right hands. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. All right, witnesses, you can sit and lower your hands. And gallery members, including teacher and attorney, coaches, family members, and friends. I don't know if there are any of those here on the Zoom. If there are, please stand and raise your right hands. Now, I can't see anybody, so technical question, I'm not sure if I can see everybody. I don't see any gallery members. Are there any gallery members? Yes, please.
Your Honor, this is Jackie. I apologize for interrupting. There are no gallery members, only the teams their scorekeepers and the panel of judges and myself are allowed on the Zoom platform. There is a YouTube real-time video that the parents and such are on for purposes of a gallery. That we're not going to access via Zoom.
We're not going to try and swear them in because of technical issues?
Well, there's no way to, they're literally just watching via a private YouTube channel right now.
Yeah. Okay, very good. All right, so everybody else can be seated and I'll have the scoring panelists please stand and raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
I do.
Thank you. You can mute yourselves again. I think that covers the oaths. And I believe, unless Jackie tells me that I missed something, that it covers the pretrial matters. I'm going to ask Jackie to direct me to what I should ask next in order to get this going.
Your Honor, I think you are ready to start. So.
All right.
Covered all of the instructions.
Okay, so in other words, I would be asking the prosecution if they're ready to give their opening statement, or am I missing anything before that?
Your Honor, may I please proceed with preliminary matters?
Please, go ahead.
All right. On behalf of both teams, let the record reflect that teams have exchanged copies of rosters and case materials.
Very good. Does that cover the
Your Honor,
preliminary matter?
I do have quite a bit more to give permission for.
Very good. You may proceed.
Your Honor, we request the court's preference on redirects and recrosses.
Hang on, you broke up, and I don't know if, and Ms. Hartman, this has happened a few times in a row with your sound. It's totally not your fault, and if I say this to anybody with respect to your sound, it is not your fault, but on the other hand, if I can't hear you, then I have a problem. And so I have a suggestion, and I want to tell you this is not your fault at all. This happens with lawyers on the phone on Zoom all the time, even if they've been practicing for 20 years. So it's nobody's fault. It terrifies me every day that I'm not going to be able to hear what's going on Zoom. I have a couple of suggestions. Most of you were coming through clear, but Ms. Hartman, every time you came on, I could hear the first sentence or two, and then it would start to break up. So it seemed to follow the same pattern every time. I'm not sure why. And one suggestion that I use often for attorneys in the real world that might apply as well to us here in the make-believe world is that usually the sound comes through better if you're dialing in on your phone for audio and using the computer just for video. I don't know if you've been trained in those differences, and I don't know if there's anything different about the technology here that might change it. So we're going to take one moment to back off of the actual substance of what we're doing. And I'll ask Ms. Hartman, I'm sorry that you're on the spot here, being the first person and having the sound difficulties. Maybe you fixed it already and you know something I don't, but otherwise, are you using your computer audio? And would it be possible to kill the computer audio and go to phone dial-in instead? And I know since you're giving the opening, I want to make sure that we, as well as the preliminary matters, that we'll all be able to hear you when you do that.
So I am not aware of how to dial in through my phone using that audio.
Right now, your sound is perfect. So maybe we'll just proceed with knocking on wood and hope that it works.
Okay, well, by any means, if I continue to have issues, interrupt me and we can try to figure that out.
I will. So sorry for the interruption, and go ahead.
All right. So continuing with preliminary matters, and pursuant to Rule 7.4, when an exhibit or during impeachment or refreshments of recollection, some other document is shown to a witness, a member of the examining attorney's team shall make that document available to all participants via screen sharing or similar technology. Additionally, exhibits or other documents posted in this manner will be deemed not to have been shown to the jury unless they are admitted into evidence and formally published to the jury.
Very good.
And then we recognize that sound quality and internet connectivity may vary, and if at any time sound quality makes it difficult to understand, that the court pause proceedings to allow witness or attorney to repeat their question or answer.
Understood.
And we request that timekeepers be allowed to post time remaining in the chat throughout the trial.
They will be allowed.
And we also request that the remaining time for prosecution closing argument to be reserved for rebuttal.
That will be allowed as well.
All right, I have no further preliminary matters for the prosecution, Your Honor.
Does the defense have any preliminary matters?
Yes, Your Honor, due to time constraints and because electronic sharing of documents for prolonged periods detracts from witness examinations, We ask that when Your Honor approves exhibits being entered into evidence, that we and opposing counsel be allowed to constructively publish to the jury.
That will be allowed.
No further preliminaries, Your Honor, for the defense.
Very good. Would it be appropriate then for me to ask whether the prosecution is ready to give their opening?
Yes, Your Honor.
You may proceed when you're ready.
Your Honor, opposing counsel and members of the jury, revenge leads to rash decisions. In the case of Avery Becker, seeking revenge for her led to the rash decision of murdering her mock trial coach, Mr. Mackenzie Brackman. Today, Avery Becker is being charged with committing the crimes of murder in the first degree and second-degree burglary of a dwelling on or about March 6, 2020 at the address of 444 South Flower Street. The charges against the defendant are not evidence, but rather accusations. We are here today to provide the evidence to rule Avery Becker as guilty of murder in the first degree and guilty to second-degree burglary of a dwelling. Now, let me give some context to these charges. Avery Becker was a senior last year at Colorado High School. Becker has competed on the mock trial team for all 4 years of Becker's high school education with teammates Alex Cifuentes and Taylor Perkins. As mentioned, the victim, Mr. Mackenzie Brackman, was the mock trial coach. Although Avery was on the varsity team and stood out in competitions, she lacked team morale and was always in disputes with her coach Brackman. Brackman demoted her to the B team after showing up late to practice too many times. Avery deviously got her position back on the varsity team, after convincing Taylor Perkins to quit the team, forcing Brackman to promote Becker. After yet another heated dispute between Avery and Mr. Brackman, Avery vandalized Brackman's car and was kicked off the team for good. At this point, Avery Becker began seeking revenge. Becker planned to break into Mackenzie Brackman's residence and vandalize it when he was not home. She shared this plan with her former teammate, Alex Fuentes, before the day of the crime. When Avery Becker did break into the house, she was surprised to see Mr. Brackman home. Once noticing the intruder, Brackman picked up the knife from his knife block for self-defense. Soon, a struggle between Becker and Brackman commenced, and Avery, out of rash decision, got a hold of the knife and stabbed and killed her coach, Mackenzie Brackman. Revenge leads to rash decisions. Our first witness today, Kyle Kuzak, is the crime scene reconstruction investigator in the murder of Mr. Mackenzie Brackman. Kuzak visited the scene on the homicide after being processed by members of the crime lab and also reviewed all of the police reports, photographs from the scene, and the videos collected from the ring security system installed at the Brackman residence. Kuzak will provide key information regarding reconstruction of this case using the evidence provided. Our second witness, Alex Cifuentes, was a teammate of Avery's on the mock trial team for 3 years. Alex knows Avery on a personal level and will provide development to Avery's character, and he also has a valuable understanding of the relationship that Brackman and Becker had. Our final witness is Detective Jordan Markowitz. Markowitz is a homicide detective with the Denver Police Department and also has a certification in cell phone technology and forensic data recovery. Markowitz was assigned to investigate the murder of Mr. Mackenzie Brackman and was one of the first to arrive on the crime scene after paramedics. Detective Markowitz will supply information regarding the scene of the crime and the tracing of Avery Becker's cell phone. We as the state have an obligation to put away criminals that commit heinous crimes such as murder. We as the prosecution have the burden of proof today to prove beyond a reasonable doubt that Avery Becker is guilty. The direct and circumstantial evidence that these witnesses will present to you today will aid you in finding that Avery Becker is guilty of murder in the first degree and guilty of second-degree burglary of a dwelling. Avery Becker's rash decision made and sought for revenge caused the death of Mr. Mackenzie Brackman. Revenge has led to rash decisions, and this revenge has led to the death of an innocent man. Thank you.
Thank you. Ms. Hartman. Let's see. I'm wondering whether we're having a technical problem at the moment because I am losing the video of most people. I can only see video of one person. Ms. Pavetti?
Yeah, Your Honor, in order for us all to be able to see the attorney speaking for the opening statement and our closing statements, we all turned off our cameras so that it would just be them spotlighted.
Okay. Very good. Thank you for letting me know. So is the defense ready for their opening?
Yes, Your Honor.
You may proceed when you're ready.
Your Honor, opposing counsel, and members of the jury, the only way to describe why we are here today is tunnel vision. My client, Avery Becker, worked with her mock trial coach, Mackenzie Brackman, for a school club for 4 years with a few other students that you'll hear from today. And after 4 years, on the day of March 6th, he was found dead. When the prosecution began their investigation, and with only a single lead, they made an arrest. Tunnel vision is the only way to describe how they worked. Avery Becker was at the receiving end of this. The day before Brackman's death, Miss Becker had lost her phone and then spent the following day with Taylor Perkins searching for it. The prosecution may say that Avery's phone, along with Avery, were traveling towards Brackman's house around the time that he was killed, but Avery was with Taylor Perkins the entire day searching for her phone. You will hear from 6 witnesses today. First, you will hear from Kyle Kuzak, who is a private investigator who has all the evidence that he has collected that is secondhand information. None of it is from himself. Second, you will hear from Alex Cifuentes, a fellow mock trial student who wanted Avery Becker off the team so they could get better roles. Finally, you will hear from Detective Jordan Markowitz, who will give detailed evidence of the crime scene, but you will also hear about how they were given a single lead and ran with it. Also, how they accepted screenshots as key evidence in today's case. They didn't investigate any other leads, but just kept saying Avery Becker committed these crimes. Then you will hear from 3 witnesses from the defense. First, you will hear from Taylor Perkins, who confirms where Becker was the day of Brackman's murder. Then you will hear from Professor Blake Van Owen, who will tell you that based on her opinion, training, and experience, that the prosecution was rushed. Finally, you will hear from Avery Becker herself. She will tell you how she didn't break into Brackman's house and that she did not kill him. You will hear about how Avery Becker and Brackman did not always get along, and about how things were said in the heat of the moment. But just because they were said does not automatically mean that Avery would go through with it. It falls upon the prosecution to bring the burden of proof beyond reasonable doubt. Reasonable doubt is a doubt based upon reason and common sense, which arises from a fair and rational consideration of all the evidence or lack thereof in the case. First, they have charged my client with criminal mischief, meaning that she knowingly damaged personal property in one specific act. Then she is charged with second-degree burglary, that she knowingly broke into someone's house with the intent to commit the crime of criminal mischief against another person or their property. Finally, she is charged with first-degree murder, meaning that she committed second-degree burglary and during the crime, a person's death occurred. The prosecution must not prove 1, but 3 crimes today. We ask you, the jury, to consider the evidence of this case and what it has brought you. We ask you, the jury, to find Avery Becker not guilty. Thank you.
Thank you. Thank you, counsel. Is the prosecution ready to call its first witness?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand.
Right. Let me ask, so far, I'm just looking at this. I don't see Kyle Kuzak on the screen, so I'm waiting for that. While we're waiting for that, Mr. DeSalvo, am I right that I don't swear in the witnesses? That's been waived, is that right?
I believe so. I believe the initial swearing in was
Covered everything, that's what I recall. And unless someone corrects me, that's my recollection from the past, and that's what we'll do. We'll assume that the initial swearing in have covered that. So I don't see Mr. Kuzak, or unless actually, I guess that would be, Ms. Ragueth. Okay. I'm pulling it together. Okay, I see.
Are you in gallery view? In your top right corner, it should say gallery view. If you click that, then you'll be able to see Nick and Kyle Kuzak.
Got it. Okay. Yeah, I think I was just a little slow in wrapping my mind around that I had to look not for the name Kyle Kuzak, but for Ms. Regetz's name on the screen. So I've caught up with that now, and I see. So thank you. And counsel, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Kuzak. Please state your name and spell your last for the record.
I am Kyle Kuzak. That is Kuzak.
And what is your profession?
I am a Colorado Bureau of Investigation Certified Crime Scene Reconstruction Investigator. This is also known as a CSR.
And what exactly does a CSR do?
The essence of a CSR work involves identification of segments and their sequencing when based on possible scientific principles in the scientific method.
And how does this analysis affect a case?
In a CSR, the analysis of evidence creates more investigative questions and hence more analysis in a quest for the best explanation of what did or did not happen. As evidence is taken in, context is also refined and the best explanation of events is shared.
And what is your experience in law enforcement?
I've spent 19 years investigating complex crime scenes in my 3 most recent years of work with the city of Denver.
What do you mean by complex crime scenes?
I've investigated home invasions, burglaries, and other property crimes. I've also investigated homicide, domestic violence, fatal accidents, and even armed robberies.
And Ms. Kuzak, what is your process in conducting investigations?
Well, I like to start with using a witness tracking spreadsheet. I then move to a flowchart and timeline, expanding the existing framework for information, evidence, and images so I can document evidentiary relationships, lab submission, and analysis.
Your Honor, pursuant to Rule 702, I am tendering Kyle Kuzak as an expert witness in the field of crime scene reconstruction and investigation.
Any objection by the defense?
No, Your Honor, we just ask that this witness stay strictly within the scope of her expertise.
All right, the witness is accepted as an expert in crime scene reconstruction and investigation.
Ms. Kuzak, when did you visit the scene of the homicide?
In about March of 2020 is when I visited the scene of Mackenzie Brackman's death. As well, I also reviewed the police reports, photographs, and even ring security videos from this case.
And may we have Exhibit 10 screen shared? And before you play that, let the record reflect that I'm showing opposing counsel what has been marked as Exhibit 10.
The record will so reflect.
Ms. Kuzak, do you recognize Exhibit 10?
Yes, I do.
And is it in the same condition as you saw it last?
Yes.
Your Honor, move to enter exhibit, what has been marked as Exhibit 10 into evidence.
Any objection by the defense?
No objections, Your Honor.
Exhibit 10 is admitted.
And Your Honor, permission to publish to jury.
You may publish.
So, Ms. Kuzak, in tracking this investigation, what important information did you gather from the ring videos?
From the evidence, it's apparent that the intruder had knowledge of the. Wait, can you repeat that? I'm sorry.
So, in tracking this investigation, what important information did you gather from the ring video?
From the ring video, I was able to gather that the perpetrator matched the same height and build as Avery Becker.
And Ms. Kuzak, from the evidence, what is apparent about the perpetrator's knowledge of the residents?
Well, from the evidence, it's apparent that the intruder had knowledge of the victim's property and residence. He likely chose a time of day when the victim's pattern would have placed him outside of the home.
And in your expert opinion, was Brackman aware of the perpetrator's presence before the confrontation that occurred?
The victim was present and alerted to the intruder's presence at the back of the house before the intruder entered. Unfortunately, in the ensuing struggle, the victim was killed with the same knife that was introduced at the encounter.
And what happened after the victim was alerted?
The victim likely looked for a defensive weapon in the knife drawer, but then he took the larger chef's knife from the knife block. The victim then confronted the intruder when the intruder entered through the back door.
And request to have Exhibit 6 screen shared for the court.
You may.
Let the record reflect that I am showing opposing counsel what has been marked as Exhibit 6.
The record will so reflect.
And Ms. Kuzak, do you recognize Exhibit 6?
Yes, I do.
And is it in the same condition as you viewed it last?
Yes.
Your Honor, I request to move Exhibit 6 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 6 is admitted.
And permission to publish to jury, Your Honor.
You may publish.
Ms. Kuzak, how would you describe the dimensions of the murder weapon?
The murder weapon used was a Chicago cutlery chef's knife. It was 12 inches in total, with the blade section measuring 7.5 and 2.5 across at its widest point, and it also had a metal handle.
And a request to have what has been marked as Exhibit 8 screen shared.
You may.
Let the record reflect that I'm showing opposing counsel what has been marked as Exhibit 8.
Record will so reflect.
Ms. Kuzak, do you recognize Exhibit 8?
Yes, I do.
And is Exhibit 8 in the same condition as you saw it last?
Yes.
Your Honor, permission to move what has been marked as Exhibit 8 into evidence.
Any objection?
No objections, Your Honor.
8 is admitted then, and you may publish.
Thank you, Your Honor. What conclusion did you draw as it pertains to the empty large size knife slot in the block, Ms. Kuzak?
The empty slot in the block was for a larger chef's knife, as you mentioned, and the knife ultimately recovered from the body of the victim was just such a knife.
So what is similar about the size of the murder weapon in conjunction to the slot size in the knife block?
The murder weapon and the slot in the knife block are very close to the same thing. The empty slot in the block was for a large chef's knife, and the knife ultimately recovered from the body was just such a knife.
And a request to have Exhibit 9 screen shared.
You may.
Let the record reflect that I am showing opposing counsel what has been marked as Exhibit 9.
The record will so reflect.
Ms. Kuzak, do you recognize Exhibit 9?
Yes, I do.
And is what has been marked as Exhibit 9 in the same condition as you saw it last?
Yes.
Your Honor, permission to move what has been marked as Exhibit 9 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 9 is admitted into evidence, and you may publish.
Thank you, Your Honor. What does Exhibit 9 indicate, Ms. Kuzak?
Exhibit 9 indicates a broken plate.
And what conclusions would be drawn from the broken plate in Exhibit 9?
The plate was knocked from the table as the two struggled from the back door into the kitchen.
And request to screen share what has been marked as Exhibit 18.
You may.
Ms. Kuzak, do you recognize Exhibit 18?
Yes, I do.
And is it in the same condition as you saw it last?
Yes.
Your Honor, permission to move Exhibit 18 into evidence.
Any objection?
No, Your Honor.
18 is admitted and you may publish.
What is pictured in Exhibit 18, Ms. Kuzak?
Exhibit 18 pictures scuff marks.
And what do those scuff marks indicate?
These scuff marks indicate the struggle that took place in the kitchen immediately inside and to the right of the back door.
Thank you, Ms. Kuzak. And request to show what has been marked as Exhibit 1 as a screen share.
You may.
Let the record reflect that I am showing opposing counsel what has been marked as Exhibit 1.
Record will so reflect.
Ms. Kuzak, do you recognize this photo marked as Exhibit 1?
Yes, I do.
And is it in the same condition as you saw it last?
Yes.
Your Honor, permission to move what has been marked as Exhibit 1 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 1 is admitted and you may publish.
Ms. Kuzak, what does this photograph indicate?
Exhibit 1 indicates Mackenzie Brackman lying on the floor where he was pronounced dead.
And after visiting the scene and analyzing all of the photographs, what conclusion did you draw as it pertains to this investigation?
After visiting the scene and analyzing each photograph, I came to only one conclusion. The victim must have been alerted by the ring security system as the intruder approached the front door. He then went around to the gate on the south side of the residence and through the back door.
And based on your analysis of the scene, where did this struggle take place?
When the two individuals struggled over the knife, the struggle moved from the back door to the kitchen table, where the plate was knocked to the ground. At some point, the intruder disarmed the victim and obtained the chef's knife.
And how do you know the intruder gained possession of the murder weapon?
Well, the location and position the knife was in the victim's body would be consistent with the intruder being in very close proximity to the victim, possibly being held in a, or constrained in a bear hug, then reaching over, stabbing the victim in the upper back and shoulder area, which is also known as the scapula.
And finally, Ms. Kuzak, after all of your careful investigating and reconstruction in this case, how would you describe this case?
In the end, this was clearly a planned burglary gone bad.
No further questions at this time, Your Honor.
Very good. Any cross-examination?
Yes, Your Honor. Ms. Kuzak, let's begin with talking about the events that took place around in Mr. Brackman's home. You say the perpetrator entered the residence through the back sliding door?
Yes, that's correct.
And you say that the struggle between the victim and the intruder occurred immediately inside and to the right of the back door?
Correct.
And right in front of the door were some scuff marks, right?
Yes.
So seeing these scuff marks led you to the conclusion that the struggle occurred there?
Yes.
But Ms. Kuzak, you can't accurately tell when these scuff marks were made, can you?
No, I cannot.
So you don't know for sure if the struggle occurred immediately inside the back door.
Correct. Except there was a broken plate that was knocked from the table.
Okay. Moving on. So after the struggle between the victim and the intruder occurred, the intruder fatally stabbed Mr. Brackman?
Correct.
Okay. And you say with an arm the victim armed themselves with?
Yes.
You say the knife used to stab the victim was a chef's knife?
Yes, it was a Chicago Cutlery kitchen chef's knife.
That you assumed came from the knife block,
Correct.
even though it was inconsistent with the knife set in the block?
Yes.
So being a chef's knife, that means it's fairly large, right?
Yes.
And after the victim was stabbed, you believed he pulled it out of his back.
Yes.
And you even stated that it would be very hard to pull out a knife due to its insertion in the scapula.
Correct.
And you also stated that the knife nicked the victim's aorta.
Yes, it did.
So a dying man who was bleeding substantially was able to rip a knife out of his back that was very hard to pull out.
Correct.
Okay. Let's move on and talk about Blake Van Owen. You dismissed Professor Owen's theory that the intruder was stabbed, that the victim was stabbed sitting down,
Yes.
because that means the victim would have been surprised by the intruder.
Correct.
And you believe the victim was notified by the ring notifications,
Yes, from his phone.
but you don't know if the victim's notifications were on, do you?
No.
You don't even know for sure if the victim was even alerted that there is an intruder.
Correct.
Okay, and in your witness statement, you say there is a broken plate on the floor.
Yes.
You say the broken plate was next to the kitchen table, which is 5 feet from the back door,
Yes, it was.
meaning it was in close proximity with the back door.
Correct.
And also in your statement, you say that there were blood droplets near the kitchen table as well.
Yes.
So if there are blood droplets by the table, a broken plate, there is a possibility that the victim could have been stabbed sitting down.
Correct.
Okay, thank you, Your Honor. No further questions.
Thank you. Let me ask a question about the rules of the contest. Do the rules allow for redirect?
Yes, Your Honor.
Any redirect?
Yes, Your Honor, a brief one. So, Ms. Kuzak, from the evidence you analyzed and reconstructed and the photographs that you viewed, what was clear about the evidence in regard to a struggle?
The broken plate could have been knocked from the table, the scuff marks as well, and the ring security video that was shown.
Thank you, Your Honor. No further direct.
Very good. May this witness be released?
Yes, please, Your Honor.
Very good. Thank you. Is the prosecution ready to call its second witness?
Judge, if I may, if you would give us just a minute to fill out our score sheets, I'd appreciate it.
Sure. Just say the word when you're ready.
Thanks, Judge.
All right, thank you. Are the people ready to called our next witness.
Yes, Your Honor.
You may proceed. Thanks.
All right, the prosecution would like to call Alex Cifuentes to the stand. May we proceed, Your Honor?
You may.
Good afternoon, Mr. Cifuentes.
Good afternoon.
What is your name and spell your last for the record?
My name is Alex Cifuentes, and that is spelled Sifuentes.
Tell me a little bit about yourself, Mr. Cifuentes.
Well, I'm a senior this year at Colorado High School, and I participated in my school's mock trial team since I was a freshman, and I take my role in the team very seriously.
How did you know Mr. Mackenzie Brackman?
Well, Mr. Brackman is, or was, my mock trial coach until he passed away, of course. Mr. Brackman was really the best. He was responsible for the success of our entire team. He influenced a strong work ethic, and he will be missed by all.
Other than a mock trial coach, are you aware of anything else Mr. Brackman was involved in?
Yeah, going along with his hard work ethic, I've gathered that he was a rather successful criminal defense lawyer, judging on his vintage 1986 Porsche 911. I know that a lawyer does not drive a ride like that unless he's good at his job. That's just how Mr. Brackman was, an inspiration to all, and an overall dedicated gentleman, no matter what area he was dedicating his time to.
And how do you know the defendant, Avery Becker?
Well, without Avery, I wouldn't be anywhere on this mock trial team. She was the one that convinced me to try out for the team in the first place. Ever since then, me and Avery have been really good friends. Best friends, you could say.
How has your relationship with Avery changed since then?
Well, since the passing of Mr. Brackman, Avery has just put some strain in our relationship. She's accusing me of stealing her phone and giving it to Blair Rollins. I would never do anything to put Brackman in harm's way. He was a great coach, and it pains me to think of someone wanting to hurt him.
Who is Blair Rollins?
I don't know. Blair is some kid that goes to our school. I know him as an acquaintance, and that accusation of me giving Avery's phone to him, a baseless claim obviously used by Avery to take some of the attention away from her. She's a rather outstanding witness on the team, and I wouldn't be surprised if she used some of those skills in this very situation.
How would you describe Avery?
Well, like I said, Avery and I were really good friends at one point in time, but she had a tendency to take things to an extreme level. She was a bit of a hothead and definitely an instigator on the team, especially when it came to threatening her position on the team.
An extreme level? What do you mean by this?
Yeah, Avery and Mr. Brackman were always going at it about each other about one thing or another. There was an incident where Avery got mad at Mr. Brackman for critiquing her work on the team, even though he's the coach, and she totally blew up and wrote "Worst Attorney Award" on the hood of Brackman's beloved car in permanent marker.
And what happened to Avery after this incident?
Well, after the incident with the car, she was kicked off the team and was pretty upset about it. She even asked me personally to talk on her behalf to Mr. Brackman about getting her back on the team, which I did because what are friends for?
Have you had conversations over text message in the past?
Yeah, we are friends after all. I even have her in my contacts.
If I showed you screenshots of a conversation you and Avery had over text message, would you recognize them?
Of course.
Your Honor, may I ask for permission to screen share exhibit number 14?
You may.
All right, what is represented in exhibit 14?
Well, it's a conversation between me and Avery, and it shows her her plan of revenge to go to Mr. Brackman's house and trash it.
Your Honor, permission to publish this to the jury?
I don't think you've moved it into evidence yet.
Okay, so my screen is frozen, so I actually can't see anything right now. It's just black. Can I ask the screen share to unshare and then share again? I'm sorry. All right, and then can you try to share again? Okay, I'm sorry, can I backtrack a little bit? So who took these screenshots, Mr. Cifuentes?
I did. I forgot my phone the day I was interviewed by Detective Markowitz, and he said I could just send him screenshots of Avery and I's conversation. And Exhibit 14 are those screenshots.
Your Honor, I would like to move Exhibit 14 into evidence.
Any objection from the defense?
No objections, Your Honor.
Exhibit 14.
Permission to publish this.
Exhibit 14 is admitted, and permission to publish is granted.
Thank you, Your Honor. What does Avery plan to do in these text messages?
Well, in this conversation, Avery expresses her anger towards Mr. Brackman, and it shows her plan of revenge of breaking into his house.
All right. Can you please stop screen sharing? Thank you. Now to the day of the murder. Where were you?
I was at school.
And was Avery Becker at school?
No, she was not.
I have no further questions for this witness at this time, Your Honor.
Okay, thank you. Any cross-examination?
Yes, Your Honor. You were on the mock trial team with Avery Becker and Taylor Perkins
That is correct.
for the past 3 years.
Yeah, that's correct.
And you say that you and Avery have always been really good friends.
Yeah, even best friends.
Yet you were happy that she was kicked off the team.
Yeah, she's a bit of an instigator, and she really put the team in a state of panic all the time. She was a good friend, but maybe not a good teammate.
You were also happy because it would give you the chance to pursue better roles.
Yeah, that's correct. But as of on a mock trial team, of course you want a better role.
Let's talk about when you got called down to the police station. You say that you did not want to rat Avery out.
No, I do not, but I wasn't gonna lie.
And you talked about the text between the two of you with the police,
Yeah, that's correct.
yet you forgot your phone.
Yeah, my phone's charging doesn't work that well, so I was charging it to make sure I could bring it, and when I went, I just totally forgot.
You say that Exhibit 14 is exactly what was on your phone when you sent it?
That is correct, and I even offered to bring the phone back but the detective told me it was okay, just send screenshots.
So that's a no.
Correct.
Oh, I'm sorry, that's a yes.
Yeah.
The police never saw them on your phone at the police station.
No, they did not.
So that means you're the only one who ever saw them on your phone.
Well, Avery too. She sent them.
But on your phone.
Oh, okay. Yeah, only my phone. I only saw it.
And that phone is now gone?
Yeah, that's correct. I got rid of it because the charging, like I said before, the charging wasn't working. So I just got a new phone.
And you have no idea where the old phone is.
No.
And a detective came by to interview you a few weeks before your statement,
Yeah, that's correct.
and you told her you were not interested in talking to her.
Well, yeah, I know she was a part of the defense, so she was just going to try to get something to impeach me.
And the job of the defense is to get the client acquitted whether they committed the crime or not.
Wait, can you repeat that, please?
And the job of the defense is to get the client acquitted whether they committed the crime or not.
Oh, that is correct.
So the defense is just trying to find an acquittal even though my client is guilty in your reports?
That is correct.
You say that Avery has...
Your Honor.
Sorry, I didn't hear you. Go ahead.
May I proceed?
Yes.
Okay, so the defense referred to the accusations of Avery Becker being guilty or not guilty, while Alex Cifuentes has no claim on whether Avery Becker is guilty or not.
Your Honor, Alex Cifuentes...
All right, you can respond.
My apologies, Your Honor. Your Honor, Alex Cifuentes has mentioned that he does think that Avery Becker has committed the crime, and I'm just asking if that was his opinion.
Objection, Your Honor. Alex Cifuentes has shared no opinions on his beliefs of whether Avery has committed the crime or not. He's only asserted his experience surrounding this case.
Your Honor, I will move on.
All right, you can move on then.
You say that Avery has an amazing ability to make things up on the witness stand
Yeah, that is correct.
and make believe anything and make it seem as though it was completely true.
That is true. She was good at being a witness.
So we shouldn't trust a word of what she says.
That is what I said, yes.
A word of what your best friend says.
Yes, that is correct.
No further questions, Your Honor.
Any redirect?
A brief one, Your Honor.
Go ahead.
Did Detective Markowitz ask you for screenshots?
Yes, he did.
Did he ask you for the phone?
Yes, he did. But wait, can you repeat that question?
Did he ask you for the phone? Let me clarify. Did he ask you for the phone after you had the interview?
No, he did not.
I have no further questions for this witness, Your Honor.
All right, may this witness be released?
Yes, Your Honor.
Very good. We'll take a moment for the scorekeepers to record their scores, and maybe scorekeepers can speak up when you're ready, and then the prosecution may call its third witness.
I'm good, Judge.
I'm good.
I'm
Your
good.
Honor.
Very good. The prosecution may call its third witness.
Yes, Your Honor. The prosecution calls Detective Markowitz to the stand.
You may proceed.
Your Honor, if I may, just ask for a brief time check from the opposing counsel's timekeeper, just to make sure that we're at about the same time, if you guys were keeping track.
Sure, go ahead.
Yes, I have approximately 4 minutes and 39 seconds for the direct.
Alrighty, thank you.
What?
All right. Detective Jordan, please state your name, spelling the last for the record.
My name is Jordan Markowitz. That's Markowitz.
What is your occupation?
I am a homicide detective with the DPD for roughly 13 years now, and I've been a detective for about 7 of those years.
How long have you been in your profession?
I am specifically a homicide detective, and I also have specialized training and expertise with cell phones. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What did you do to earn your certification?
I had to complete a training course and pass an exam in order to receive my certification.
What experience do you have in your expertise of cell phone technology and forensic data recovery?
I personally have downloaded the contents of hundreds of cell phones, and I've also used cell phone tower data on a regular basis. I've obtained and interpreted cell phone tower data in over 50 cases.
Your Honor, under Rule 702, I move to enter Detective Jordan Markowitz as an expert witness in the field of homicide investigation, cell phone technology, and forensic data recovery as they satisfy the qualifications of knowledge, experience, and education in the fields that I previously stated.
Very good. Any objection by the defense?
No objection, Your Honor. We ask that the witness stay strictly within the scope of her expertise.
Very good. The witness is accepted as an expert in homicide investigation, cell phone technology, and forensic data recovery.
I'd like to direct your attention to March 6, 2020. What happened that day?
In March 2020, I was assigned to investigate the death of Mackenzie Brackman, a criminal defense lawyer.
How were you notified of the crime?
Paramedics had arrived to the scene and saw Brackman deceased just inside the front door, and I was called shortly after.
What did you do?
At first, I saw the Ring doorbell, and I secured the perimeter immediately after.
Did you see anything?
Yes, I noticed a side gate to the backyard was unlatched and I found that the back door was open. So I entered the residence through the back door, which took me to the kitchen.
What did you see inside Mr. Brackman's residence?
Everything was in disarray. A knife drawer was partially open. There were some broken plates and a knocked over chair on the floor.
What did you do after you saw the knife?
I didn't go to it. I actually had my forensic team process it, and I looked around the rest of the house for any other evidence or victims.
What did you discover?
Nothing of value seemed to be missing. There was a laptop computer and several flat screen TVs that had been left undisturbed.
What is your expert opinion on the events leading up to the crime?
Based on the number of homicides that I have investigated, it seems fairly obvious that the victim had caught someone breaking into the home and had likely confronted the intruder with a large knife from the kitchen, but the intruder must have gotten control of the knife and stabbed the victim. It seemed most likely that the victim went to the front door after being stabbed, either running away from or after the intruder.
Was there anything else from the crime scene used as evidence?
Yes, actually, I started downloading the contents from Brackman's cell phone, and I found a tremendous number of text messages and emails talking about something called the mock trial, and I got a hold of the school where he coached, and I was able to speak to Alice Cifuentes.
What knowledge did you acquire about the case from him?
When I interviewed Alex and his parents, I acquired some screenshots of text messages between Alex and another possible suspect.
Which suspect is that?
Another former CHS mock trial participant, Avery Becker.
Why do you suspect Avery Becker?
According to Mr. Cifuentes, Mr. Brackman had recently kicked off Avery Becker from the mock trial team after Becker had vandalized Brackman's car, and Alex got a text from Avery's phone.
Tell us about the cell phone records.
The CDRs that I had taken from Avery Becker's cell phone had confirmed that around 1:05 p.m. to 1:07 p.m. Becker was at Brackman's home, and between 12:45 to 12:50 p.m. That's when she started traveling towards Brackman's home and heading there based on the location analysis of the CDR.
What is your expert opinion on Avery Becker's involvement?
Sorry, that's time.
Okay. No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Before we begin, may I inquire to my timekeeper as to how much time I have left?
Yeah, you may.
You have 12 minutes and 27 seconds.
Thank you.
Can I interrupt for 1 second? I'm going to ask the scorekeepers to confer with me for a moment and make sure that we're filling out the scoring sheet right. I realized I was a little uncertain about one part of what I was doing on it, and I want to see if the scorekeepers are doing it the same as me or different. And of course, if any of the participants have been instructed on this, you can tell us the right way. But I realized I was uncertain when I've been filling out the score sheet. What I'm uncertain about is the right-hand column, the defense side. So for instance, for the first, on the right-hand column, near the top of the first page, it says cross-examination D1. I inserted my score there on the understanding that what we were talking about there is the defense cross-examination of the prosecution's first witness, and that was entered there rather than at the bottom, that the bottom half of the page was going to be for the defense half of the case. But now I realized I was uncertain and wanted to make sure. Can scorekeepers tell me, are you doing it the same way? Using the, where it says cross-examination. Sorry, go ahead.
Judge, I am doing the same as you.
Yeah, that's right, Judge.
Okay. Okay, very good. Thanks. I just wanted to make sure because we'd be making a real mess if we were doing it differently. And so, thank you. Sorry for the interruption. Counsel may proceed.
Detective Markowitz, let's talk about the day of your investigation. Your team took several photos throughout your investigation?
Yes, we did. We took photos all over the scene. We have some that have been instated today as exhibits. However, one of those files was corrupted, but it wasn't that much of a loss because we do still have a multitude of images.
But these corrupted photographs could not be recovered?
No, there's only one small portion of images that were corrupted. It was a blood splatter image. However, my analysis was mostly based on the CDR, placing the suspect at the crime scene as well as other portions of it. So it was lost, but it did not severely hurt our case or analysis. No, it didn't.
And let's discuss your knowledge of the victim. You recognize the victim?
Yes, I had actually been cross-examined by this attorney before.
And you stated that you've had the displeasure of being cross-examined by him.
Well, I wouldn't say any cross-examination is pleasant. However, I did meet him before.
Now let's go back to the evidence you found. There are 4 ring videos which you examined?
Yes.
And the person in the video has no identifying features showing?
We can see the general build and height of the intruder. However, they were wearing slightly baggy clothing and a mask, so I wasn't able to completely identify it. It was a little bit difficult, but we do have the general height and build of them.
So that's a no.
Would you restate your question, please?
That's a no that the person in the ring videos has no identifying features showing?
No, that's actually incorrect. We do have the general build of the person, and height and size is also a factor in our analysis. So no, my answer is no.
But several people have the same height, build, and size, Detective Markowitz.
I would say so, but in regards to our suspects, it let us narrow it down a little bit to the people that we already had suspects, because I'm not just going to pull somebody out and say, oh, you're this height and size, you did this crime. Absolutely not. It just was another contributing factor in order for us to narrow down the suspects that we had already had.
And you consider that this could have been the work of a disgruntled ex-client based on the fact that Brackman worked in criminal defense?
Oh, absolutely. It could have been a multitude of things. Things like this happen almost randomly. Could have been a million people that had vendettas, and that's why we furthered our research once I did get to the scene and downloaded the contents of his computer in order to actually narrow that down until we got our suspect, Avery Becker.
But you never investigated the theory that it could have been the work of a disgruntled ex-client?
I did not think it was probable based on my evidence, which I found sufficient, as well as my colleague Kyle Kuzak's evidence. They all leaded towards this particular suspect, Avery Becker, and she was placed at the scene at the date time based on her CDR call detail records. So she was my main suspect.
Thank you. Is that a no?
I analyzed. So what would I said that I investigated.
You never investigated the theory?
Probable. If you could not interrupt me, I'm so sorry.
Of course, my apologies. It must be my internet. You then downloaded the contents off of Brackman's phone?
Yes, I did, as I said previously.
And you knew how to do this because you took a 3-day training course?
Yes, that was my initial training course, but as I said in my direct, I've done this in over 50 cases, and as of now, I have quite a bit of experience with the trade.
And that's when you discovered Brackman's activity as a high school mock trial coach?
Yes, I found Brackman's affiliation, and after that, I chose to delve deeper and contact the school and get some interviews with people like Alex Cifuentes.
You then believed that Brackman's mock trial activity was not related to his death?
During my analysis, I researched a multitude of different scenarios on what it could be, but the mock trial and his mock trial affiliation is what I delve into the most.
And you followed this up because you state good police work requires you to follow up on all possible leads.
Oh, absolutely, probable leads, and that's why I did that.
So let's move on to you investigating Brackman's mock trial activity. You spoke with a student named Alex Cifuentes.
Yes, I had an interview with Alex and his parents.
In fact, that was the first person you contacted.
Yes.
And afterwards, you tried to contact Avery Becker.
I did try to contact Avery Becker. I tried to set up an interview, but after I scheduled the appointment, her parents had hired an attorney and I was no longer able to speak to Becker. Everything had to go through her attorney first.
But you didn't try to contact anybody else afterwards.
No.
And based on the conversation that you and Alex had, his parents agreed to come to headquarters to conduct a full interview?
Yes.
And it was during the interview that you learned about text implicating Avery Becker at the crime scene.
Yes, I did. I also tried to get these same text messages from Avery's phone, but that's when I figured out that Avery's phone had been missing. So the text messages that I got were from Alex's phone sent from Avery.
But you did not ask to see Alex's phone to download that information.
No, I was sent the content in order for us to use it today in court.
Because Alex did not have that phone on them on that day.
No, not at that time. So I was just sent it.
And that surprised you.
Yeah, I would say so.
In fact, you stated that that might have been the only time that I have ever encountered a teenager who did not have their cell phone with them.
I thought it was kind of weird at first, but then after I got forwarded the information, I did try to get another source of information, but Avery Becker didn't have her phone either, so that was the most efficient way for me to collect the content.
So you accepted screenshots of the text messages that Alex had sent?
Yes.
And those texts were sent the day after the interview?
Yes, they were.
And earlier on, you testified that you have downloaded the content of multiple cell phones throughout your career?
Yes, I have.
You also testified to downloading the contents of Brackman's cell phone.
I did.
However, you did not ask Alex Cifuentes to bring in their cell phone in order to download those contents.
Initially, I didn't find it necessary, being that Alex was not an initial suspect, and I just needed the small portion of messages from his cell phone, so I was just forwarded it.
And isn't it possible that those screenshots could have been tampered with?
Possibly, but I did try to clarify, and the Becker portion of the side was not willing to give me any sort of screenshots or text messages from their side. So Alex Cifuentes was the best evidence we had.
So you accepted alleged screenshots without confirming their authenticity?
I suppose you could say that, but I didn't find a reason why Alex would tamper with it, so of course I accepted it. It was the only way to get the evidence at that portion of time.
Now let's move on to the chart made by Kyle Kuzak. You knew Kyle Kuzak?
Yes.
And you knew that they were brought in as another expert in today's trial?
Yes. She testified earlier in this court.
And she created a document which states the key points and suspects of today's case, correct?
Yes.
You never state that you saw that document?
Not in my affidavit. However, it was provided for us in court today, so if it was entered, then we would all be able to see it.
But you never saw that document?
Not
prior
previously.
to
As you stated before, it is Kyle Kuzak's document, and I brought forward my own evidence as well. So that was Kyle's document, and it has not been entered. So no, I had not seen it.
So you had no idea that Alex Cifuentes, the person you found trustworthy, was listed as suspect number 2?
No, I had not. Me and Kyle did not communicate that, and it was not shared to me for any reason. So no, I did not know that.
And you also had no idea that Blair Rollins was suspect number 3?
No, also, as I stated before, my investigation was completely separate from Kyle Kuzak's. Although she is my colleague, we did do 2 separate analyses in order to create a multitude of suspects and probabilities for the case. So no, we did not share our content. We created our own individual analysis so that we could compare later.
Let's discuss what led you to your conclusion. You concluded that Avery Becker vandalized Brackman's home in the middle of the weekday because you believe that Avery came to the conclusion that Brackman would be at work at the time?
Yes, I did. It seems like the intruder had known a time that Brackman would have been away, and that is the time that they chose to approach the home.
But you have no evidence to back this assumption up.
I did get those the screenshot text messages, and I also have a plethora of CDR analyses that base her from going from Becker's home, going through the most logical route to Brackman's home, and then a timestamp of her at Brackman's home with her cell phone.
And you also have no proof that Brackman was alerted about the intruder via the Ring doorbell system?
Well, generally, rings do notify the phone holder or the owner of the house when somebody comes, but it's a possibility that he was not notified.
And you state that you follow where the evidence takes you?
Yes, I do.
And the contents you downloaded from Mackenzie Brackman's phone took you to the mock trial team?
Yes, absolutely. I followed the most probable suspect and possibilities, and that's what led me here today.
Right. Any redirect?
No, Your Honor. At this time, the prosecution rests.
All right, thank you. Let me give the scorekeepers a moment with their scores. And let me ask counsel, I can't recall whether there's a break here or if we push on to the defense case.
Your Honor, there is no break.
All right. So I'll just wait to hear from the scorekeepers when they're ready, and then we'll move to the defense case.
Judge, I'm ready.
I'm ready.
Me too, thank you.
Very good. Then defense counsel, they call their first witness.
Defense calls Taylor Perkins to the stand.
And you may proceed.
Please state your name, spelling your last for the record.
Taylor Perkins, Perkins.
Speaking of talking about the days around when Mr. Brackman was killed, what did you do the afternoon of March 5th?
Well, Avery came to my house and we were playing games on our phone after school.
How do you know Avery Becker?
Oh, she's my best friend. Honestly, I wouldn't have done mock trial without her.
Did you do anything else after you played games on your phone?
Yeah, we went to the Fry Shack, which turned out not to be the best idea.
Why not?
Well, members of the mock trial team came in after practice and just kept talking about how unfair it was that Avery got kicked off the team.
Why did Avery get kicked off the mock trial team?
As per usual, Brackman was upset with her about something. So they got really mad at each other, and Avery went outside and wrote Worst Attorney Award on the hood of his car in permanent marker. But I know she thought it was dry erase.
And did Avery try to get back on the team?
Oh yeah, loads of times. She kept trying to apologize to Brackman, but he never took it, which was totally unfair.
Let's go back to the Fry Shack. Did anything happen there?
Yeah, Alex Fuentes came in and just kept talking about how unfair it was that Avery got kicked off the team. It was so annoying.
Okay, and how did Avery feel about this?
Avery got really upset. She stormed off to the bathroom. I don't remember if
Objection,
she grabbed
Your
her
Honor.
phone or not.
Speculation.
All right, go ahead, counsel, you can respond.
Your Honor, I am simply asking this witness of how he perceived Avery Becker to seem in this instant.
All right, any response?
Your Honor, the question does call for the witness to speculate on the grounds of how Avery felt, and I don't believe that witness can testify to Avery's feelings.
All right, I'll sustain the objection if defense can lay a foundation for testimony with direct knowledge, they can follow up on that, but the objection is sustained.
Okay, Mr. Perkins, how did you feel about Alex Fuentes saying these things?
It was so annoying. I mean, he's always annoying, but at that time I just wanted to punch him in the face.
And what happened after that?
Well, Avery stormed off to the bathroom and then she came back after a while and we left, but I don't remember her ever grabbing her phone.
Okay, let's talk about the day of March 6, 2020. What did you do that morning?
Avery drove me to school. Sometimes on days I drove myself, but like that, when we both had first period off, I just rode with her.
And did Avery have her phone?
No, she wasn't responding to any of my texts, which I thought was weird. So I suggested we take the day off and go look for it.
And did you?
Yeah, but we never found it. We went back to the fry shack, but they didn't seem to have anything. So after that, we just went our separate ways.
Were you with her for a majority of the day?
Yeah, I was with her pretty much all day until after the fry shack when we parted ways.
Okay, thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. You were on the same mock trial team as Avery Becker, correct?
Yeah, of course. She was my best friend.
And you wouldn't have done it without Avery, right?
No, I didn't have much interest in it, to be honest, without her.
And Mackenzie Brackman was your mock trial coach?
Yeah, but not a great one.
You and Avery thought that he was a mediocre coach and lawyer.
Yeah, like I said, those who can do and those who can't coach.
And you believe that Avery was the best lawyer on the team?
Yeah, I mean, she came in and didn't really even have to try and always got awards. It was great.
You say that Mr. Brackman didn't like Avery?
No, he found it pretty annoying that she did that.
Mr. Brackman always gave her a hard time, right?
Yeah, exactly.
Mr. Brackman would sometimes get visibly angry and mad at Avery.
Yeah, it was a little funny.
But Avery also has an inflated ego and can sometimes be rash.
I mean, I don't know about an ego, but everyone on the team's a little rash sometimes.
And once Avery was knocked down to B team, you quit the team in order to force Coach Brackman to put Avery back on A team. Is that right?
Well, I stepped down in support of my best friend.
So you therefore sacrificed your spot on the team for Avery?
Yeah, but like I said, I didn't have much interest in it without her.
And Avery told you about the practice where everything blew up.
Yeah, she told me how upset she was and how she didn't mean to draw on his car with permanent marker.
And Avery was upset with Coach Brackman for being mean?
Yeah, but she tried to apologize and get back on the team, so she must have forgotten about it.
And she was so upset, in fact, that she wrote on Mr. Brackman's Porsche in permanent marker?
Yeah, but like I said, I know she thought it was dry erase marker. She didn't mean any harm by it.
After that, Mr. Brackman kicked her off the team indefinitely.
Yeah, I believe so.
And when you were at the fry shack with Avery, she got upset once more and stormed off to the bathroom?
Yeah.
And Avery's very attached to her phone, right?
Yeah, but I can see her leaving it sometimes. Like I can see her leaving it. It's not out of her character to do that when she's really upset.
Well, you do say it's never out of her reach, correct?
I mean, yeah, it's never out of her reach, but
You even go as far to describe it as her third kidney.
yeah, I mean, it's just a dumb saying, but
And finally, Mr. Perkins, would it be reasonable to say that Avery gets angry often?
uh, she gets angry a lot, but it's not like super bad all the time.
Thank you, Mr. Perkins. No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Mr. Perkins, why did you drop out of the mock trial team?
To support Avery, I mean, she's my best friend, so.
And is it all possible that Avery always had her phone on her?
I mean, not always. Like I said, she wasn't responding to my texts, so. Plus, after dinner, I think her parents took it.
Okay. Thank you, Your Honor. No further questions.
All right, thank you. May the witness be released?
Yes, Your Honor.
All right, very good. And we'll wait for a moment for the scorekeepers to record their scores and let me know.
Your Honor, if I may, I wanted to just clarify a couple of things on the score sheet you had asked about earlier. I want to make sure everybody is using the score sheet the way it was intended, so we don't have issues at the end.
Thanks.
May I? Okay. So the way the score sheet was designed is it kind of goes from side to side. So you're going from left to right to left to right to left to right as you progress down the through the trial, just like you're going plaintiff to defense throughout the trial. So this tracks the order of the trial. And does that make sense to everybody?
That's good. That confirms, I think that was what I was asking everybody. That confirms what I think, what I understand, and what I think the other scorekeepers said as well.
Okay, perfect. I just wanted to make sure since there had been a few questions.
Yeah, thanks. Much appreciated.
I need a clarification then based on what I just heard. So with the defense, wouldn't that go right to left and not left to right?
So well, for defense, it is going to go right to left to right.
Okay.
If you look at it, you just look at, you're going to follow this down and it zigzags back and forth across the page.
Okay, perfect.
Based on, yeah. Okay, thanks.
Very good. No, we appreciate all those. We appreciate all those clarifications because it would be a disaster if we were doing it wrong. So thank you. I assume that the scorekeepers I think they're done, and so the defense may present their second witness.
Thank you. This calls Professor Blake Van Owen to the stand.
You may proceed.
Your name spelling the last for the record.
Blake Van Owen, VANOWEN.
And what do you do for a living?
I am a professor, a private investigator, and sometimes I'm even an expert witness in police practices.
And what is your educational background?
I earned my bachelor's from CU Boulder in 2005 and my master's on criminal justice from Ashford University in 2015.
And did you gain any experience after you graduated?
Yes, after I graduated, I started working for the Aurora Police Department. Afterwards, I became a school resource officer, a private security guard, and then went into private investigation.
And what else have you done to further your experience?
I also, as a professor, lecture classes at CU Denver on police practices and social justice. I also lecture classes at the Community College of the Rockies on police procedures.
And what else do you do aside from teaching?
I've also been admitted as an expert witness in about 6 different states.
And how many cases have you been an expert in?
I've been an expert in over 100 cases.
And what were you an expert in during those cases?
I was an expert in multiple types of police practices, as well as crime scene reconstruction, cell tower analysis, and and general investigation tactics.
Your Honor, at this time, I ask that the court accept this witness as an expert as she has shown extensive skill, training, knowledge, and experience pursuant to Rule 702.
In what area?
In the fields of crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Any objection?
Brief voir dire, if I may, Your Honor.
You may.
So you joined the Aurora Police Department in 2005, is that correct?
That would be correct, yes.
But you only stayed with the department for a total of 9 months?
That is also correct.
And that's because you injured a woman of color during an arrest?
Objection, Your Honor. My witness is...
Go ahead.
My witness cannot testify to this as she has signed a confidentiality agreement, and that is between her and a separate party, and therefore cannot discuss the details of said confidentiality agreement or what was within the confidentiality agreement in court today.
If I may
All right,
respond,
prosecution.
that is the extent of my question on that. I am not asking for any details regarding that. I just wanted to, for Van Owen to give an explanation for the termination of her time at the department.
Why don't you re-ask the question to focus it in the way you're asking?
I can simply just move on as well.
All right.
So after this incident, were you disillusioned with police work due to its tactics and techniques?
During the time, I believe so, yes, which is part of the reason why I quit to pursue my master's degree in criminal justice.
And you quit the force in 2005, is that correct?
That would be accurate, yes.
But in 2014, you received a Master of Arts in Criminal Justice from Ashford University?
Yes.
Through an online course, that is?
Yes.
And since then, you've been teaching a police practices and social justice course at CU Denver?
Yes, that is correct.
Since you got that degree in 2014?
Yes.
Your Honor, I have no objections to this witness being entered as an expert as long as they stay strictly within the guidelines that they have been entered in.
Very good. Then the expert is accepted. And counsel, for the defense, would you just repeat what the area was? I didn't write it down entirely. The area of expertise.
Crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Very good. The expert is accepted. The witness is accepted as an expert in those areas.
Now, let's talk about your involvement in this case. Can you tell the jury how you got involved in this case?
I got involved when I was hired by the defense.
And does that have any effect on your opinions in this case today?
No, of course not.
And what is your expert opinion on the practices done in this case?
Based on my training and experience, it is beyond argument here that the police investigation was rushed. When you're rushed, you miss things. This group missed a lot of important things.
And what led you to that conclusion?
I have viewed the police reports on this case, as well as Kyle Kuzak's report from their crime scene reconstruction, Detective Markowitz's report on cell tower analysis, and I even conducted my own partial investigation and parts where I believe were neglected by the police.
And did you agree with any reports or evidence given by the prosecution?
I agree that there's evidence that points towards a break-in of Brackman's house, but other than that, no.
Now, let's talk about Kyle Kuzak's evidence in this case. Did you review the evidence given by Kyle Kuzak?
Yes, I did.
And what did you not agree on with regards to Kuzak's evidence?
Kuzak opines without support that the intruder was surprised by Brackman, and Brackman had grabbed a knife from the knife block, and within a struggle, Brackman was disarmed by the intruder, which then lodged the knife into his left shoulder.
And after reviewing the reconstruction done by Kuzak, what is your expert opinion on the report?
In my opinion, the report is very unreasonable.
And why do you say that the report is very unreasonable?
First, the only apparent evidence of a struggle are supposed scuff marks on the floor. Those scuff marks could have been made a year ago, 5 years ago, who knows?
And do you agree with Kuzak's description of the struggle with the knife?
No, I do not.
Why not?
The evidence that points towards a struggle, it would mean that in order for the intruder to have lodged the knife in Brackman's back, is if they were in a face-to-face, the intruder would have had to have been much bigger than Brackman. From the ring videos, however, it shows that they are not very big. Therefore, it would make more sense for Brackman to have been sitting when the knife was lodged into his back.
And can you demonstrate how the knife would have been lodged in his back for the court?
The intruder would have simply held the knife like this, the handle gripped comfortably in their hand, and they would have raised the knife and lodged it down into their shoulder.
Now let's talk about the evidence prepared by Detective Markowitz. You heard Detective Markowitz testify earlier in court today?
Yes, I did.
And do you agree with Detective Markowitz's conclusions on the Ring app?
As a Ring app user myself, I know that you could turn off the push notifications. And if we had Brackman's phone in court today, we would know whether those notifications were on or off. However, even if the Ring push notification was on, that still doesn't necessarily mean that Brackman would have seen it. People nowadays have many notifications, and sometimes it just feels good to step back.
And do you agree with Detective Markowitz's opinion about the call detail records?
No. The detail records, yes, show that Becker's phone was connected to the cell tower near Brackman's house. However, that doesn't necessarily mean that Becker was even near the house at the time. Cell towers are made to cover many, large areas, and in rural areas, it could cover hundreds of square miles. However, in suburban areas, it could cover a 6 to 7 mile radius.
And in your expert opinion, what would the better practice have been for gathering the call detail records?
If I was looking into it, I would have made sure to
Your
look
Honor,
at.
I object
Go
to
ahead.
the relevance of this question.
I only heard part of what you just said. You object to what?
I object to relevance, and I can also explain if you'd like me to.
Go ahead.
I object to relevance of this question just because we are here today to examine and go over the events that have taken place and not necessarily how Miss Van Owen would have done things in a different way. We are here today to address the innocence or guilty measures of Avery Becker, and I don't understand how this would be relevant, how Van Owen would have done something different.
And go ahead, you can respond.
Thank you, Your Honor. The evidence gathered by Detective Markowitz is what we are basing whether or not Avery Becker, our client, is guilty or innocent on. And if Detective Markowitz, or if Professor Van Owens found fault with Detective Markowitz's gathering of the evidence, I feel like that should be explored and what could have been done to improve, as that is also her field of expertise.
All right, the objection is overruled for the reasons stated by the defense. You may answer.
Do you need me to re-ask my question?
Yes, please.
In your expert opinion, what would the better practice have been to download the call detail records?
If I were to do it, I would have made sure to look into other cell phone records that had connected to the same tower that Becker's did. Therefore, finding anyone else who could have been closer to Brackman or had a stronger motive to kill him.
And are cell phone tower data and GPS data similar in any way?
No. Although they sound precise and scientific, they are not in any way, shape, or form the same. If we had Becker's phone in today's case, we would have been able to track the GPS data and figure out where the cell phone was at the time of the murder.
Now let's talk about the alibi of Taylor Perkins and Avery Becker. Earlier in court, you heard Taylor Perkins testify?
Yes, I did.
And is there any evidence you found to confirm this alibi?
Yes. When I looked closer into the cell tower records, I found that there was many calls and texts coming off of the tower 1191, which had later on moved to antenna 3 of that tower, which also received calls and texts from Perkins' phone, which is located by the fry shack where Perkins had stated they had ended up.
Now, let's discuss your personal findings. Why did you conduct a personal investigation?
I did my own personal investigation because I believe that there were many places neglected by the police.
And is this documented somewhere?
Yes, it's documented in my report.
Your Honor, I request permission for the witness to view what has been pre-marked for identification as Exhibit 20.
You may.
Can you please identify this document?
Well, this is my report on this case.
And who made this document?
I did.
And when did you make this document?
I made it after I was hired by the defense.
And is it true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time I move for the admittance of Exhibit 20 as its accuracy shown and authenticity stipulated to.
Right, any objection?
No, Your Honor.
Exhibit 20 is admitted and you may publish.
Thank you. What did you discover when you conducted your own personal investigation?
I found someone with a stronger motive to kill Brackman, and that person is Blair Rollins.
And why do you say that?
In an earlier case, Blair Rollins' father, Jonathan Rollins, was convicted of murder as a client of Brackman.
And did you ever listen to the recording of that case?
Yes, I did.
And would you be able to identify in court if it were played again?
Yes.
Your Honor, permission for the witness to view what has been pre-marked as Exhibit 22?
You may.
Can you please identify this document?
This is the recording I heard from that court case.
And when did you hear it?
I heard it while I was conducting my own investigation.
And is it true and accurate to the...
Yes.
Your Honor, at this point, I move for the admittance of Exhibit 22 into evidence as its accuracy shown and authenticity stipulated to.
Any objection?
Yes, Your Honor. I object on regards to that we've only seen, it looks like, a link of this document, and nobody in the courtroom, including the witness today, has heard or I guess it's an audio recording. Nobody has heard this in the courtroom today, so I don't believe that this can be entered into evidence.
Do you want to respond to that objection?
Your Honor, I was under the impression that I would play the audio recording after it had been admitted as evidence as to not construct the jury to form their own opinions other than based on evidence. However, if it is no trouble at all, I request permission to play it for the jury.
All right, and the people's response to that?
That sounds like a great idea to me, Your Honor. I have no further objections after this.
All right, Exhibit 22 is admitted and it may be played for the jury.
I'll get you back, Brackman, if it's the last thing I do.
Now, Professor Van Owens, can you tell the court more about Blair Rollins?
Yes, as I was doing my own personal investigation, I found out that Blair Rollins in the CHX yearbook had the same shape and body build as Becker. And when I looked a little deeper, I also found out that they were not only missing of the day of the murder, but they also have disappeared after graduation. And I think it would be safe to say that they are no longer in Colorado.
And what else did you find on Blair Rollins?
I also found out that Blair Rollins and Alex Cifuentes were friends, meaning that Cifuentes could have easily taken, stolen, or even found Becker's phone and created those fake text messages with Blair Rollins.
And are there any other ways that Blair could have gotten Avery's phone?
If Cifuentes helping Rollins is too cloak and dagger for you, it is likely that Blair Rollins could have found Becker's phone at the Fry Shack themselves. Since the Fry Shack is a very popular place for high school students, it would make a lot of sense for them to have found it there.
And in your professional opinion, do you believe Avery Becker committed this crime?
No, I do not. Although it could be an option and it could be a reason, that doesn't necessarily mean that they looked into anyone else besides Becker, so we will never know who actually committed the murder.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. Good afternoon, Mrs. Van Owen.
I'm sorry, I prefer to be addressed as Professor Van Owen.
Of course, good afternoon, Professor Van Owen.
Thank you.
So you've said that you've been an expert witness before, is that correct?
Yes, that is.
But only as a defense witness.
Yes, that is true.
Okay, now regarding the case today, you know Kyle Kuzak on a professional level, is that correct?
Yes, in some matters.
And do you think he's rather egotistical?
Yes, when you give him an idea, he usually runs with it.
And you do not agree with Kuzak's theory of this case that we're presenting today?
No, I do not.
You even think that there are areas of this case that were neglected by Kuzak?
Yes.
And the rest of the police force along with Kuzak?
Yes, that is correct.
But then again, you don't agree with the policies of the police force in general, do you?
Not 100% no, but I don't really see.
However, you agree with Kuzak that the on-scene evidence in this case points to an intruder who broke into Mr. Mackenzie Brackman's home?
Can you please repeat that?
You agree with Kuzak on the fact that somebody did break into Mr. Brackman's home?
Yes, that is correct.
But one detail of the case that you believe is that there was no presence of a struggle between the victim and the murderer. Is that correct?
Yes, although it could be an option, I believe that there was neglection of any other options.
And you believe that there wasn't a struggle even though that there were scuff marks on the floor?
Those scuff marks could have been made a year ago, 5 years ago. You have no idea, no one has no idea when those scuff marks were made. Yes, they could have been made during a struggle, but there is no clarification to identify so.
But those scuff marks were by the door, regardless whether or not they were formed recently or 10 years ago.
Yes, they were.
And that's where the dead body of Mr. Mackenzie Brackman was found as well, near the door.
The scuff marks were made by the back door. However, the body was found by the front door.
Okay, just moving on. You also believe that the murderer brought the knife onto the scene of the crime?
Once again, it's a strong possibility.
Due to the fact that the murder weapon was a different brand of the knife from the block that was present at the scene of the crime?
Well, yes. The knife could have came from anywhere. It could have came from within the home. It could have came from outside the home. We have no idea where it came from. We just know that it was there.
Do you have a theory of this case? Do you believe that the knife came from outside of the home?
Objection, Your Honor. Compound question.
I can cut that down.
Go ahead.
Do you believe that the knife came from outside of the home?
Personally, yes, but that doesn't mean that it's true.
Well, that is what we're arguing today. So you believe this even though that it's pretty common for knives to be replaced if they're damaged from a knife set?
Yes.
Now, moving on to the cell tower information provided in this case, Avery Becker's phone was near Brackman's house at the time of the murder. Is that correct?
No, actually, the phone was giving off signals to the cell tower near Brackman's house, but that doesn't mean that the cell phone was anywhere near Brackman's house.
But it was the cell tower closest to Brackman's house.
Yes, but cell phones are made to connect to the tower with the best signal, which doesn't necessarily mean it's going to connect to the nearest one.
But it was the one closest to Brackman's house.
Yes, it was.
But even despite this phone, you believe that Blair Rollins is a more reasonable suspect in this case over Avery?
Yes, I do.
And you believe that Blair Rollins had Avery's phone at the time of the murder?
I believe that it's a reasonable option, yes.
Even though any route that Blair Rollins would have taken going from their house to Brackman's to cause the phone to ping off those same cell towers would have been out of a direct and reasonable route to take?
Can you please rephrase the question?
So from Blair's house, if Blair had possession of that phone, any route that Blair could have taken from their house to Mackenzie Brackman's house for it to ping off of those cell towers, that would have been a very indirect route way to get from Blair's house to Mr. Brackman's home?
Yes.
And was Avery at school at the time of the murder?
No, they were not, but there is an alibi as to where they were.
But Avery wasn't necessarily accounted for at the time of the murder?
No, they were not, but neither was Blair Rollins or Taylor Perkins.
And her phone did ping off of a cell tower near Mr. Brackman's home?
Objection, Your Honor. Asked and answered.
You can respond.
I'm just asking for some more clarification on this, just because we did receive a fairly long answer earlier.
All right, the objection is overruled. You can answer.
Do you want me to restate that?
Yes, please.
So Avery's cell phone was pinged off of a tower closest to Mr. Brackman's house?
Yes, but like I stated before, they could have been further away, as cell phones are made to connect to those with the best signal, which doesn't necessarily mean the closest one.
Okay, I have no further questions for this witness at this time, Your Honor.
All right, thank you.
May I request a time check, though, however?
Sure.
So I don't know who's keeping time, but what's the time for the directs on defense?
The defense has 3 minutes and 36 seconds left.
Okay, thank you.
All right, any redirect?
Just a brief redirect, Your Honor. Does having your cell phone ping off a tower mean that you yourself had the cell phone?
No, it does not.
Thank you. No further questions, Your Honor.
All right, may this witness be excused?
Yes, Your Honor.
Very good. And we'll wait for a moment for the scorekeepers to record their scores. They could let me know when they're ready, and then the defense may call their final witness.
I'm ready, Your Honor.
I'm ready.
Me too, Judge. Thanks.
Thank you. Next witness then. Thank you.
Your Honor, the defense calls Avery Becker to the stand.
Very good. You may proceed.
Before I begin, Your Honor, may I inquire to how much time I have left?
Sure, go ahead.
You have 3 minutes and 30 seconds left.
Thank you. Please state your name, spelling the last for the record.
Avery Becker, Becker.
And how old are you?
I'm 18.
What school did you attend?
I was a senior last year at Colorado High School, or CHS.
Did you do any clubs or sports in school?
I was on the CHS mock trial team all 4 years of high school.
Did you enjoy participating in mock trial?
Yes, I was looking forward to winning Best Attorney in the State Award.
And who was the coach on the mock trial team?
Mackenzie Brackman.
Let's talk about your relationship with Mr. Brackman. What was it like?
Mr. Brackman was always criticizing my work. He thought I should have every question written out, and it was a common argument between us.
How else would you describe your relationship?
It was rocky. We never got along, but just because we would fight doesn't mean I'd break into his house or even kill him.
Did Brackman ever punish you?
Brackman was going on about my lack of preparation and demoted me to the B team.
What happened after you were demoted?
My best friend Taylor quit the team, and Brackman had no choice but to put me back on the A team.
Did you and Brackman have any other altercations?
Well, there was the car incident. I felt so bad for what had happened.
Could you elaborate on that?
After regionals, Brackman was going off on me, and I stormed out of practice. I had a dry erase marker in my hand, and when I saw his car, I wrote Worst Attorney Award on it. Then I realized it was a permanent marker.
What happened after that?
When Brackman came out and saw what I had done to his car, he went off on me and officially kicked me off the team.
How did you feel after you got kicked off the team?
I was angry and upset, but then I talked to my mom and she calmed me down, and I decided to go to Brackman's office the next day to apologize, but he wouldn't see me. I then texted that I was sorry, and he never responded. I never got to apologize in person either.
Let's talk about the text messages between you and Alex Fuentes. You heard Alex testify about them?
Yes, I did.
Could you refer to Exhibit 14?
Yes.
Did you send those messages?
No, I wouldn't do that. I never texted Alex. Alex would be the absolute last person I'd go to for help on anything.
What was your relationship like between you and him?
Alex is such a brown noser. I don't know why he pretends we are friends. We've never gotten along.
Where were you the day that Brackman was killed?
I was with Taylor the whole day.
Why?
The day before, we had gone to the Fry Shack and later the mall before going home. The next day, I couldn't find my phone, so we decided to ditch school to go look for it.
Did you break into Mr. Brackman's home?
No.
Did you kill him?
No, I wouldn't do that. Just because I didn't like him doesn't mean I'd kill him. He did help the team be competitive and top. The only thing I'm guilty of is riding on his car, not killing him.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Last year, you were a senior at Colorado High School.
Yes.
Mackenzie Brackman was your coach?
Yes.
You thought Brackman's ego was really something.
Yes, it was.
Even going so far as to call it massive?
Yes. I mean, he had litigator on his license plate.
You thought he was a joke.
Yes.
He always criticized your work?
I won awards to prove I was good. It didn't need criticizing.
He would call you lazy,
Even though I'd win, yes.
and you told him that he wouldn't know a good cross if it hit him over the head.
Yes, I did.
Because of your lack of preparation, Mr. Brackman bumped you from A to B team.
Yes.
He thought you'd focus better without Taylor Perkins, your best friend.
Yes.
He refused to put you back on varsity.
The A team, yes, he did.
That is until Taylor resigned.
He had no choice but to put me back on the A team.
You knew Taylor was willing to take the fall for you before he quit.
Taylor quit because Taylor wanted to quit.
And in fact, he did end up taking the fall for you, correct?
Rephrase.
Taylor ended up taking the fall for you by quitting.
That's not taking the fall from me. Taking the fall is taking the blame. He just quit the team.
All right, moving on. At regionals, you won 2 awards.
Yes, I did.
And at your Tuesday practice after regionals, Mr. Brackman didn't congratulate you.
No, he criticized me instead.
In fact, he said that you didn't deserve best attorney.
He did say that.
And that you wouldn't fare well at state.
Yes, and I stormed out of practice because I couldn't take the insults.
And he said you only rely on good looks.
Yes, it's probably the only compliment he's ever given me.
You were really angry.
Yes.
So you wrote on his Porsche, as you stated before.
I thought it was dry erase marker.
And you wrote this in giant letters.
Worst attorney award. I still thought it was dry erase marker. I offered to scrub it off and get a summer job to repaint it.
And you wrote this across the hood of the car?
Yes.
And you did this knowing that he loved his Porsche?
Yes, I did, but I was angry. I thought it was a dry erase marker. I thought it'd come off.
And when Mr. Brackman found out, he said that he had enough of your crap?
Yes, he kicked me off the team because of it.
And he said that you were disruptive?
Yes.
He called your best friend a loser.
Objection, Your Honor, relevance.
You can respond.
I would say this is relatively relevant because calling someone's best friend a loser could establish possible motive against said person.
Your Honor, if I may, she is bringing up Miss Becker's best friend, and I do not believe that has any relevance on her motives, if she had any.
Your Honor, if I may.
You may.
Well, they were best friends, and Mr. Brackman calling Avery's best friend a loser to her face does actually have some relevance because that could have impacted the relationship between Mr. Brackman and Avery.
The objection is overruled. I find it's relevant toward motive.
All right. Do you want me to restate the question?
Yes.
He called your best friend a loser?
Yes, but Brackman's always insulted me. It's not any different from before.
And just to be clear, after he kicked you off the team, you were more mad than when you vandalized his car?
I suppose you could say that. I was very angry.
On March 5th, 2020, the day before the murder, you claimed to have lost your phone, correct?
Yes, I couldn't find it March 6th.
Even though there's evidence that your phone was near your house?
Doesn't mean I had it. I had no idea where it was March 6th.
You claim to have never sent those text messages to Alex?
I wouldn't do that. I wouldn't go to Alex for help on anything.
You claim to have an alibi on March 6th?
Taylor, me and her ditched school to go look for my phone. It's a very expensive phone my parents would have.
Sorry. Taylor Perkins, the friend who quit mock trial just so you could compete on A team?
Yes.
Your Honor, this question's already been answered.
You can respond.
Taylor?
Your Honor, I am just continuing to state this to reinforce the fact that Taylor Perkins, her alibi, was the person who also quit the mock trial team, to clarify.
The objection is overruled. Follow-up questions on the subject are appropriate.
Okay. I'll restate my question. Taylor Perkins, the friend who quit mock trial so you could be on A team, is your alibi?
Taylor quitting mock trial was her own decision. She never really liked it.
But Taylor Perkins is your alibi, correct? Your best friend?
Yes.
And finally, Ms. Becker, when you were dismissed from the team, you stated that you would get back at Coach Brackman if it was the last thing you did.
To my mom, but she calmed me down and convinced me to apologize instead.
Is that a yes?
Yes, I did say that, but I was calmed down.
You were calmed down when you stated that?
My mom calmed me down after I said that and convinced me to apologize.
So, okay, no further questions.
Any redirect?
Yes, Your Honor. Why did you say that to your mom and not whenever you were angry?
I was mad, but my mom calmed me down and I apologized to him instead, or tried to.
Did you mean it?
In the moment, I suppose I did, but I was calmed down.
Would you go through with it?
No.
No further questions, Your Honor.
Very good. The witness may be excused.
As well, Your Honor, the defense rests at this time.
Okay, very good. I think we had a discussion at the start and said everyone could have a minute if you would like before the closing arguments. So we'll just take a minute and then I'll hear the prosecution's closing argument.
Judge, can we take more than 1 minute? I've been sitting at my desk for 3.5 hours and absolutely have to have a break. I'll be back in 3 or 4 minutes.
That counts as a medical emergency.
Thanks, Judge.
We'll take 3 or 4 minutes.
Judge
Sorry, go
Bentley,
ahead.
this is Jackie. I also want to make a couple of announcements, but I'll wait till Mr. Berg is back. Just about some of the bookkeeping and things toward the end of the competition. But I'll wait and give Mr. Berg a chance to get back.
Very good. Okay. We'll take 3 minutes here. Thank you. And I'll step away as well.
Thanks, Judge. I'm back.
Excellent. All right, I think Jackie wanted to make a few announcements.
Yes, Your Honor, thank you so much. First thing is all parties, all participants, all scorekeepers, all timekeepers, and our presiding judge are asked not to leave this Zoom meeting room until we, this end, have confirmation that all score sheets have been submitted. I want to remind the scorekeepers that you are supposed to pick a best attorney and best witness. They can be from the same team, they can be from different teams, but it's just one collectively of each of those. You do have to choose a winner, whether it's the prosecution or the defense. It cannot be a tie, both score-wise or who the winner is. So your actual numerical scores cannot be tied, and who you deem winner cannot be a tie, or you have to pick plaintiff or defense. If you are a petitioner, if you let's say you mark the bubble for the plaintiff as being the winner, I know that says plaintiff, but we're really prosecution for that, then their score has to reflect also that they won. Does anybody have any questions about what I've just said? Doesn't sound like it. So I will end up confirming with Jason that the score sheets have been submitted, and then I will get back on and let you guys know that they've been submitted and we have confirmation of that. And then so I'll ask you just to wait until I come back on to give you that after closings. All right.
Very good. If everybody is ready, we'll proceed and we'll hear the prosecution's closing argument.
And just to be clear, before I begin, I'll be given the time stamp in the chat. 5, 4, 3, 2, 1. Just from
Yes.
the okay, thank you. Your Honor, members of the jury and opposing counsel, revenge leads to rash decisions, and there is one thing that has become abundantly clear after the witness testimony that we have heard today. And it's that Avery Becker has a known history of acting irrationally. Avery Becker has a known history of making rash decisions. Avery Becker has an inflated ego, and Avery Becker is known for not being able to handle criticism, especially when that criticism comes from Mackenzie Brackman, although it is constructive criticism. In fact, when someone does offer up constructive criticism, Avery Becker does this. She figuratively and quite literally stabs them in the back. Avery Becker stabbed Mackenzie Brackman in the back. Now, members of the jury, before I proceed, you are given jury instructions in this case, and allow me to read jury instruction number 7 to you. The elements of the crime of murder in the first degree, felony murder, are that the defendant in the state of Colorado, at or about the date and place charged, acting alone or with one or more persons, committed or attempted to commit second-degree burglary, and in the course of it or in furtherance of the crime of second-degree burglary, that the defendant was committing or attempting to commit, or in the immediate flight therefrom, the death of a person other than one of the participants was caused by anyone. Allow me to detail this known history of irrationality from Avery Becker. We've heard the story about Mackenzie Brackman's prized Porsche, the Porsche that was taken to with a permanent marker by Avery Becker, where she wrote Worst Attorney Award on it, on that prized Porsche. Now, the defense has attempted to downplay this as Avery Becker not really believing that it was a permanent marker. But members of the jury, any rational person would not write on a car in general, especially after hearing news that that they were removed from a mock trial team, something so minuscule. They would not go to those lengths to seek revenge, but that's something Avery Becker did. No rational person would write on a car in general, regardless if that car was theirs or not. We also have to talk about Taylor Perkins, someone who knows Avery best. Taylor Perkins testified to saying that Avery Becker has an inflated ego and that sometimes she can act irrationally. This is someone who knows Avery Becker best, but also it's clear to you members of the jury that Taylor Perkins was willing to sacrifice being on the mock trial team for Avery Becker. And a question to keep in mind, if Taylor Perkins was willing to sacrifice this for Avery Becker, what else is Taylor Perkins willing to sacrifice for Avery Becker? We also saw the text messages that clearly show Avery Becker had the means, motive, and opportunity to break into Mackenzie Brackman's house and cause as much damage as possible. Although the damage to property was minimal, there was damage in regard to the life of Mackenzie Brackman. Avery Becker took Mackenzie Brackman's life in the ensuing struggle. We heard expert witness testimony from Kyle Kuzak with 2 decades of experience in crime scene reconstruction and investigation that Avery Becker matches the general height and build of the person shown in the ring videos, the perpetrator in this case. But something, members of the jury, that you should take note of, something that the defense admittedly did very well. They gave Avery Becker minimal time in direct examination. Why? This was not by mistake. They know that if they gave Avery Becker any more time to talk about herself, that you, the members of the jury, would clearly see who she is as a person. Members of the jury, you saw Avery Becker on full display through the witness testimony of others in this case. Now, it's up to you to make sure that she doesn't get away with what she's done, that her ego is not inflated anymore by knowing that she can play you, the members of the jury, in her favor. Members of the jury, you know what to do. You know what's right. Avery Becker is guilty on all counts. Thank you, and the prosecution rests.
Thank you. The defense may give their closing argument.
Thank you, Your Honor. Your Honor, opposing counsel, members of the jury, this case was viewed one way and one way only, through tunnel vision. Today you heard from 6 witnesses. The 3 witnesses brought to you by the prosecution tried to convince you that Avery Becker was nothing more than some delinquent kid with a grudge. And as for the constructive criticism that they want you to believe that was given to Avery Becker, last time I checked, constructive criticism is not calling somebody a loser or saying that their best friend is a loser. First, from the prosecution, you heard from Kyle Kuzak, who based their entire theory and work off of inconclusive evidence. That evidence being a broken plate, scuff marks, and a knife inconsistent with those in the blocks that they said could have happened from that struggle, but could have is not did. Nor does their theory make any sense, as how can a dying man pull a knife from their back after being fatally stabbed? Next, you heard from Alex Cifuentes, who claimed to be best friends with Avery Becker, despite being jealous of Avery Becker, despite being glad that Avery Becker was kicked off of the mock trial team, and who honestly refused to talk to the defense simply because they were defense. And last, you heard from Detective Markowitz, who, we should also take note, did not finish their time, was given little time to talk, because they would know that if they kept talking, they would admit to faulty police work. A seasoned detective of years taking a course on downloading hundreds and hundreds of contents off of cell phones, and yet the ones implicating our client today is just not used, is not downloaded. Instead, what was good enough was screenshots that could have been doctored, that could have been altered, that could have been faked. in implicating this. From the defense, you heard from Taylor Perkins, who states that they were with Avery Becker that entire day and who parted ways after Mackenzie Brackman was murdered. Next, you heard from Professor Van Owens, who states that the evidence gathered by Detective Markowitz actually supports this alibi, as the phones that Taylor Perkins was connected to was from the mall and the Fry Shack, which were Avery Becker and Taylor Perkins were. Not only that, they also brought you another possible suspect, not even considered by the prosecution in today's case, and that person is Blair Rollins, who heard their father scream, I'll get you back, Brackman, if it's the last thing I do. Your Honor, members of the jury, this is tunnel vision, deliberately focusing your entire theory of the case on one person, which is exactly what happened, because Detective Markowitz decided to interview one person and one person only, Alex Cifuentes, and is practically accusing Avery of this crime of second-degree burglary and felony murder based off of the fact that she refused to talk, exercising her Fifth Amendment right. And from Avery Becker herself, you heard that it was a heat of the moment thing. But let me ask you this. Is a rash decision one to apologize? The prosecution has the burden of proof to prove that Avery Becker broke into the house of Mackenzie Brackman, and during a burglary, Mackenzie Brackman was killed. However, we, the defense, have not only has the prosecution failed to do this, we, the defense, have brought you somebody else with an even stronger motive. This is reasonable doubt, and therefore we are confident that you, the jury, will come back with a verdict of not guilty. Thank you.
Thank you very much. And thank you, everybody. Let me ask Jackie if that leaves anything other than pausing while the scorekeepers pull together their scores.
Nothing. I was just going to suggest that the scorekeepers finish up their scores and submit them. And while I'm confirming that we've received them and that we don't have any questions, let our judging panel briefly give some feedback to the students.
Very good. So we'll fill out our scorecards, and then I'll ask. Maybe we can hear from the judging panel after we've done that briefly, and then I'll add a few comments at the very end. Jackie, let me just ask, so you want myself and the scorekeepers to just press submit when we're done? Would that be right? Want to make sure, not pressing that button until it's the right time.
Yes, go ahead and submit when you're each done. And if you guys will let me know that you've submitted, then you guys can start your feedback, and I'll go check with Mr. Downey to be sure we've received them and viewed them and make sure we don't have any questions.
This is Tim. I've submitted.
Okay, thank you, Tim.
This is Carl.
This is Judge Bentley. I've submitted. Oh, except it told me it was an error.
Oops.
This is Carl. I've submitted.
I'll work.
Okay.
Jackie,
Yes,
I
sir.
hit submit. I'm getting a message that says error processing entry, internal server error.
Okay. Are you able to look back at your score sheet and see if there were any columns that did not have a numerical value in it, even if it was a 0?
I'm going back through it right now.
And then did you mark a winner?
Everything, all the numbers were filled out, and I marked a winner and the best attorney and best witness.
Okay.
I don't know, it says internal server error, which sounds different than filling it out error, although I don't know.
Okay, let me run check with Jason and just see if that could be something on our end, and then I'll come right back, okay?
Okay, and I can hit print or maybe convert it into a PDF and email it if you need some other type of solution like that.
Okay, let me talk with Jason and see what he wants to do. We may have to have you maybe PDF it, do some way and send it to us. So hang on just 1 minute.
Sure, okay.
Your Honor, I have submitted my score.
Thank you. Everybody's done except for me. So, I mean, I thought I was done, but okay.
Text it to me or email it.
So, Your Honor, it appears that Judge Billings Vila had the very same error. So I'm wondering if there's a server issue maybe at the courthouse that won't allow you guys to submit. So what we did with her is she printed it, took a photo of it, and then emailed it to Mr. Downey. So would you be able to do that?
Yeah, and I think
or
that
you can text it to us, whatever is
I
easier.
think I believe I've saved it as a PDF and I can email it. Let me
okay.
see if that's the case.
Yeah. I'll wait until you tell me you've sent it. And then
Sure.
As soon as you've sent it, then you guys can start your feedback. Mr. Brown, did you submit your score sheet?
I did.
All right, thank you.
I have it printed. So what I need to do is go back to my office where my phone is and take pictures of the 3 pages. And then where do I email it to?
So send it to, I'm just going to give you Mr. Downey's work email address rather than, that is probably going to be the easiest.
Yeah.
So Mr. Downey's email address is jdowney, DOWNIE, at SMMCLAW.com.
smnclaw.com?
No, it's SM as in money, M as in money, C as in candy, LAW.com.
So S is in Sam, M is in money, C is in candy, law.com. SMC law.
Your Honor, there are two M's. It's SMMC law.
Okay. Sally, money, Nancy, C, law.
No, Your Honor, it's two M's as in money.
Double the money, Judge.
Double the money. Right, Carl.
SMNNC law.
No, Your Honor, I'm sorry. Let me type it in this chat real quick, okay?
Yeah.
Does that work? Okay.
Yeah.
And Judge, while you do that, I would suggest that Mr. Calling, Mr. Brown, and I give our reviews. I know
as long as Jackie will allow it, I think that would be great.
That's perfectly fine, Your Honor. Did you get this?
One second. I'm struggling to get back to the right screen. I apologize. I could see Mr. Berg there.
Well, you're going to be in the chat window.
Okay, now I'm okay. I'm back, and I got it. And okay, very good. I've got it.
Okay, perfect.
So why don't the scorekeepers go ahead, and I will be. I'll just be away from the screen for the time it takes to do this.
So if you don't mind, I'll go first. This is my first opportunity to participate in these mock trials. So I want to thank Mr. Brown for the opportunity to volunteer for this. I incredibly impressed with the preparation that these young adults put into this. The composure, the
He's
pressure.
emailing it to your email address.
This is,
Your
I am very happy that I had the opportunity to do this, and I wish I had taken advantage of these types of opportunities when I was your age. Because seeing where you are from a trajectory standpoint, it's very impressive to see young adults handle themselves the way that you did during this trial. So I'm incredibly impressed with all of you, and I'm incredibly impressed with this entire process. So I just want to thank you for allowing me the opportunity to be a part of it.
Could I jump in and just ask each of you scorekeepers, as you give your feedback, to just tell them a couple of sentences about each of yourselves?
Tim, go ahead.
Say a couple of sentences about myself.
Yeah, so they get to know who's evaluating them. If you don't mind, that would be great.
So I've spent 20 plus years in the healthcare field, so I am not, this was an opportunity for me. I've been a part of many juries, so I've seen things from this perspective, but it was nice for me to see, number one, how the last year has impacted how, I guess, this process works. But at the same time, this allows me an opportunity to take some of the things I learned here and bring it back into my profession. So this is outside of my scope, but at the same time, it was nice to be able to see the organization, to be able to see the information presented, and how this group operated, and how well prepared they were for everything that happened in the last 4 hours. Just incredibly impressed.
Mr. Brown?
I really want to echo what Tim just said. And I just, I've done this several times, and I'm always impressed with the preparation and the poise of of all the teams that participate. It's incredibly competitive. And this particular mock trial was the same. I mean, it just comes down to splitting hairs. And I just love it. And I think that everybody benefits. I think the students benefit and the scorers benefit and probably the judges too, because everyone is so well prepared. So those are my comments. My background, I've been a real estate broker in Colorado Springs for 40 plus years. And I've always been in business, and I love what I do, and I'm passionate about it. That's my background.
So my name is Carl Berg. I'm a construction attorney. I've been doing it 30 years. I try and arbitrate a lot of cases for contractor clients. This is probably my 15th year doing this mock trial judging. I think this year for you students, you had extraordinary challenges because of the format that we struggled with somewhat. The older folks like us aren't as good with the technology as perhaps the younger people are, and we're kind of set in our ways. But I think despite those challenges, everyone did a very good job. I echo the prior comments in terms of the preparation. I know, having tried lots of cases, big and small, the amount of effort it takes. A couple just general questions or general comments regarding the presentation. Mr. DeSalvo, you got a lot of exhibits in with your first witness. I like seeing exhibits. Judges, juries, arbitrators like exhibits better than they like testimony. But you need to provide a little more context for those exhibits for the jury. Remember, the jury doesn't know any of the facts. You have to tell them the complete story in the presentation. And frequently, your foundation, you'd show the video, but we didn't know whose house that was. We saw the guy walk up with the mask. We don't know whose house it is or what the setting is, for instance. And then you went through the pictures on the inside of the house, show a broken plate. Where is this? W5, who, what, where, why, when. Lay that foundation so that the jury, who doesn't know any of the facts, gets that piece of the puzzle. So I like the exhibits. I'd like to see more objections because I think objections can be very effective. I think using the Zoom format makes it more difficult because of the delay. So there were some really good relevance objections. Ms. Hartman, there were a couple points there during when you were doing the cross-examination of Blake, I believe, and you let the expert report come in. Expert reports are never admissible because they're cumulative. Always object to expert reports. And then you made a good objection about the audio tape, which wasn't going to help the prosecution. But then you said, well, we have to hear it. Well, once the jury hears it, you can't unring the bell. So I understand there's an issue there. But at the same time, that wasn't favorable evidence. You should have requested that the jury listen or the judge listen to it, because once the jury hears it, we've already heard it, whether the judge sustains the objection or not. Overall, I think both parties had good themes. The presentation was pretty easy to follow, but once again, just remember, the jury doesn't know the facts. Only you know the facts. You have to put every piece of that puzzle into your trial strategy and presentation so that it's cohesive, so we understand it. So good job, everyone. I appreciate the opportunity to do this.
I guess it's my turn, and it's my turn, Jackie, if you received my email, and that unseals my lips and allows me to talk, or if Jason received it. I sent it. So.
Yes, Mr. Downey has received it. He's just reviewing it to make sure we have no questions, but you can go ahead and give your feedback.
Okay, thank you, everybody. This was amazing. And first, so I'm Eric Bentley, and as I mentioned at the start, I've been a judge here in this building and in this courtroom for 4.5 years. And before that, I was a lawyer for about 20 years. I was a federal prosecutor in Washington and Philadelphia at the start of my career, and then came out here because my wife got a job at Colorado College, and I did commercial litigation for about 15 years, and then took the bench. And being a judge is one of the most amazing jobs you could ever imagine. I recommend everybody to keep that in mind. If you're thinking of being a lawyer, keep it in mind as a career track, but something that you look for. It's hard to look that far ahead. You'd look for it at maybe 15 years after law school to do that. But I did divorce cases and civil cases, and now I do criminal cases and civil cases. And it's amazing the variety and the number of cases you get to do, the impact you can have on people's lives. So anyone who might be thinking about being a lawyer, it's not impossible to become a judge in Colorado. Colorado has one of the best judge appointment systems in the country. We're all very proud of how it's done. It's nonpartisan, based on merit. There's a lot of opportunity for people if you're interested in that career track. I just want to say how amazing I find it every year when I listen to all of you and see all of you. And we're going to do soon the college mock trial. But I always find it's amazing. High schoolers, you're just about as good as most of the college competitors. It's amazing. I never in a million years would have had the ability in high school to do what you're doing here. I would have been utterly terrified to stand up and question people assertively and make the speeches and the closing and in the opening and closing statements. So I want to just stress how very, very hard it is what you're doing. As lawyers and judges, we still struggle with all these same issues in trial. Maybe after 20 years of being a lawyer, it's still really difficult. And it requires you to be a performer. It requires you to be a storyteller. It requires you to dig down deep and analyze facts, look for discrepancies. It requires you to learn all kinds of areas that you never otherwise would have gotten to. All of those areas of expertise that your experts put on as a lawyer, you get up there in court and you're cross-examining doctors and forensic investigators, cell phone tower analysts, and it has the excitement of you learning something in days or weeks or months that someone else is spending a whole career on. So I just really want to emphasize how difficult this is and how great you all did, and your commitment and your professionalism is superb. And I obviously keeping all the scores that I had to do to myself, but you both got 10 on professionalism, and many of the lawyers who appear in this courtroom could learn from you all in terms of your professionalism, your courtesy to the other side, and your care for the rules and principles at stake. I want to echo the couple of criticisms I was going to mention. The constructive criticism, really, Carl got there ahead of me. I had a real question about maybe I'm missing something in the rules that you apply here. Sometimes the rules you apply are different from in a real courtroom. So I had a real question. I wondered what was going on, that nobody was authenticating exhibits in the way that you would actually do in a courtroom. I think the questions were basically, do you recognize this as in the same condition as when you saw it? Okay, I move to admit it. That's not sufficient under the rules, and it may be that your teachers and coaches will come back and say, well, we have different rules here. But without going into the details, that's back to your coaches to ask them if they have different rules, because if not, that is not proper authentication. And I would have sustained objections to every single exhibit on the basis that the simplest authentication and most important authentication question you ask is, what is this thing? Do you see what's been marked as Exhibit A? What is it? How do you know? That's basically authentication, and is very simple, but is very important. And it wasn't being done, so that's a question back to your coaches, because I'm not quite sure why that wasn't being done. It was on both sides, so it was clear that you were taught to do it the way you were doing it. Same also what Carl mentioned about telling a complete story. That's maybe the most important and one of the most difficult trial skills that, again, you could spend many years mastering. You're telling a story to jurors and a judge who don't know anything about the facts of your case until you tell them. You may have spent months preparing this, and that would be true in real life as trial attorneys as well. And so almost all lawyers then kind of assume, they're so deep into the story, they kind of assume everybody else gets it. But we don't. We don't know anything about it. We don't know who the people are until you tell us. So a huge skill you have to get is first you have to get in deep into all the details, and then you have to learn how do you step back and explain it to someone who knows nothing about it, and pull it together in a coherent story to someone who knows nothing about it. That's essential for openings and closings. Closings, obviously, we all know a lot more than we did at the start, but it also comes up with a direct examination of the witness. You're telling the story. Who are these people? How do they fit in? And you're linking that to your theory of the case. So that's incredibly difficult skill. You guys are all getting started on that. You could all learn more and improve in that area as you go forward and on to the next rounds. I was very impressed with some of the cross-examinations, and I have to say I think the prosecution team has probably a particularly good coach on cross-examination, because I think you all had a similar style. You used short affirmative statements. You were comfortable dominating the witness, telling your story with a series of short affirmative statements. Someone must have taught you well. I was impressed with that. I'm impressed with all of you. Keep it up. Congratulations. I wish you all the very best of luck as you go forward in the competition and in your lives. Thank you to everybody.
Your Honor, with regards to the documents not being authenticated, it's stipulation number 1 that those documents are accurate, and then as well as the chain of custody is not up for dispute on those documents.
Okay, very good. No, thank you for that, because as I mentioned at the start, I don't know I haven't had the time to study your rules and some of those stipulations, so I stand corrected on that. Just know that that's pretty different from how it would be in a real courtroom, but obviously your job is to follow the rules you got, so thanks for that.
And on behalf of both teams, we would like to thank all of you for being here, especially during these unprecedented times. We appreciate your efforts into making this happen. So we just want to thank you very much.
And this is Jackie back. We do have all score sheets in. So thank all of the teams for their participation this evening and for our judging panel. We could not do it well without you guys. Have a wonderful evening. And normally we're telling you to have a safe trip home, but I'm hoping every one of you are at your homes. Well, I'm not either. So have a wonderful night, and we look forward to seeing you in other rounds.
Good luck, everyone.
Thank you.
Everybody, good luck.
Good night.